I would remind you, if you are involved in an impounded case, to please be sensitive to ensuring that the names are not shared. So if it's child or an initial, please do so. We use the clock timers, green light to yellow light to red light, almost like an airplane, right? No emergency exit at the appeals court, though. When the red light comes on, please stop your argument. If the panel has any further questions, we'll make sure that we ask you. Finally, and probably I saved the best for last, we have read everything, and we are ready to hear your argument. I would suggest that you get to the heart of the matter. 15 minutes goes by quickly. And so with that, let me call the first case, which is docket number 24P1327, TOMASO versus the Commonwealth of Massachusetts. Attorney Bartman.
Thank you, ma'am.
Good morning. Nice to see you.
Nice to see you too, Your Honor. And good morning. May it please the court, I'm Frederick Bartman, and I represent appellant in this matter. The overarching issue that resulted in him not receiving a fair Section 9 trial is that the qualified examiners should not have been allowed to rely on either the Hopedale police report or the Rhode Island police report, in that neither of them contained reliable statements that provided an independent basis for their admissibility in terms of them being from dismissed charges. And so to get at the heart of the matter is that this is a man who had a robust criminal record, including an indecent assault and battery and other offensive sexually related offenses, but all were from the early 1990s and earlier. Other than the two dismissed allegations that were far more serious and provided really the sole bases for the diagnoses of the mental abnormality of sexual sadism. And if those reports could not be relied upon by the qualified examiners, it presents a vastly different set of facts upon which the jury would have made a determination as to whether or not he remains sexually dangerous some 35 years after the conviction.
So can I interrupt you for a moment?
Sure.
Qualified examiner can or cannot consider dismissed charges?
They can consider dismissed charges as long as there's an independent basis for admitting the underlying allegations that were contained in this instance in two different police reports. And in this particular case, in both instances, these charges were dismissed because of credibility issues pertaining to both victims.
Isn't that a separate issue, though, in terms of cases get dismissed all the time for various reasons, right? But that doesn't prevent the Commonwealth from trying to bring in those witnesses, even if they weren't available or for whatever reason decided not to cooperate in the underlying criminal case. That doesn't preclude them from being brought in.
So generically speaking, I think that's a fair statement. There could be all kinds of reasons why these allegations were dismissed. But in this case, you have a prosecutor who stated in open court at the time of the plea to the assault with a dangerous weapon charge out of Hopedale that based on trial preparation and conversations with the alleged victim, that the sex offenses became difficult to prove. Now, what does that mean? We have no idea what that means without a voir dire, at minimum of the qualified examiners. We don't even know if a supplemental police report was generated from additional information that was provided on the brink of trial that resulted in the dismissal of those charges. We just don't know.
Did you ask, you asked for a Lanigan hearing with respect to the qualified examiners,
So
right?
that was part of the motion in limine, but
Yeah.
there was also a request under what I've characterized as footnote 5 of the Marquardt decision, which is if it is not clear whether or not there's an independent basis for admissibility of the allegations, then the court should conduct a voir dire.
So it's clear that the court didn't conduct a voir dire, right? Accepted this as independent. What's the prejudice when overall there certainly are other, as you admitted, instances of behavior that certainly seem to be more damning for your client?
Sure. So the prejudice to my client is that those two cases, the Rhode Island case and the Hopedale case that we've been talking about, immediately preceded his incarceration, and he has not been in the community since that date. So in terms of that becomes almost a contemporaneous public display of behavior for the jury to be considering, other than all the years of containment that resulted in a lot of other behavior that certainly they could consider, as Your Honor is discussing. So the prejudice is that the most serious diagnosis was sexual sadism that related to the two dismissed charges. And without those police reports, there is very unlikely to have been a sexual sadism diagnosis. And without those two police reports, and any connection, and I would submit there was significant connection to the assault with a dangerous weapon charge, the jury was left to consider the behavior that Your Honor is talking about, which certainly concerning, certainly potentially can meet the requirements of the elements for continuing to be a sexually dangerous person, but it was, I hate to use the word, but minor in comparison to the sexual sadism diagnosis.
But so the convictions that were there was grabbing a victim's breast in a public setting and fondling a person's breasts on a bus. And you're saying, well, that doesn't rise to the level of sadism, unlike the rape
Correct.
charge. That's your
Correct.
argument? Yeah.
That was a part of what is clearly a robust antisocial history that this man had based on a personality disorder. And that kind of behavior continued not only during his years of incarceration, but frankly during the trial itself. And so the jury would still have to consider, okay, this is a gentleman with a pervasive personality disorder, but how does that relate to whether or not some 35 years after the incidents that Your Honor is talking about, is he still likely to reoffend sexually if released into the community?
You don't argue that the qualified examiners couldn't take into consideration the charges, correct?
So
that comes in.
Sure.
Just normally, right?
That's actually the second issue that I raised in my brief, which is, again, under the circumstances of this case, those charges were not just admitted for what the judge described in his final instructions as just part of his general criminal record. Mm-hmm. It was clear from testimony, from reports, and even the other aspects of the final charge that those dismissed sexual offenses that were provided to the QEs and that were provided to the jury were related to the dismissed sexual assault charges, especially the Hopedale charges. It's inescapable based on, a continuing drumbeat of how the testimony came in, even as redacted, how the qualified examiner reports came in.
Did any of the examiners recount the underlying facts of those charges? You say it's inevitable, but I just, why exactly do we know that the facts of the underlying charges came in?
And just so I make sure I understand your question,
I guess my premise is we all agree that the charges themselves could have come in. They could have come in on their own. They did come in on their own through the court records. Those could be considered by the qualified examiners. Your point is, well, they shouldn't have been allowed to consider the underlying facts of those charges. And how do we know that was considered and that evidence was brought to the jury?
So the dismissed charges, which were multiple, multiple counts of rape and kidnapping and indecent assault, were all under the same docket number as the assault with a dangerous weapon charge. And there was reference in my colleague's opening statement that the dismissed charges were related to the assault with a dangerous weapon.
But let me just make sure that I'm clear. The jury never heard the underlying facts and circumstances surrounding the allegations, right?
Correct.
And so so it makes it difficult to really define the question of prejudice because we don't know exactly, but we do know that the jury never heard the underlying facts. The jury saw the docket, some serious sexual assaults that were one of the last times that your client was living on the outside, and the jury considered the qualified examiner's opinion of the sexual sadism, right?
Right.
So the facts never were before the jury. They form the basis, in part, of a diagnosis, which, correct me if I'm wrong, appear to be admissible. And since we're viewing this under the lens of abuse of discretion, I'm trying to really pinpoint where the judge abused discretion.
Sure. So in this particular case, I think the diagnosis of sexual sadism is what is sort of the final straw that links the dismissed charges to the assault with a dangerous weapon. And so to the judge's credit, to the lawyer's credit, I think everybody worked really hard to try to untangle what was and wasn't admissible. But in this particular case, even if they didn't get the details of what the rapes were, how could they not have at least in part associated, well, whatever these allegations were, they were related to the assault with a dangerous weapon charge, and clearly, because it's the only evidence, along with Rhode Island, to base the diagnosis of sexual sadism. And so I think since there's language in many of the appeals court and SJC cases that talk about the radical departure from the rules of evidence that these trials present for everybody, not at the trial court level and here. And I think it's very hard to have a one-size-fits-all series of cases and rules that we follow, and then it's going to be easy to follow those in every instance. This case really did present that challenge, and there may be a way to allow the dismissed charges as a core entry into evidence, but in this particular case, they were related in opening statement. They were related because the definition of a sex offense can include a violent offense that has as its underlying motivation sexual misbehavior.
Can you just,
Excuse me.
with your limited time, and this goes to Justice Tan's question earlier, that I think the judge concluded, well, that the qualified examiners could rely on the police reports because the relevant witnesses would still be allowed to testify, right? And that's sort of, I think, what Mark Vart says. So why is that wrong here?
Because in this instance, there was no independent basis to admit the evidence. And the burden is on the Commonwealth to provide reliable evidence upon which the jury's going to make this determination. And in this particular instance, where the issue with regard to both victims in the dismissed cases was their credibility and the inability to sustain these charges, and we don't know what that is, it then becomes the government's burden to and frankly, possibly through a voir dire of the QEs, to determine whether or not there was an independent basis, which I submit there was not here.
I see that your time is up.
Right. Thank you very much, everybody.
Thank you. Attorney
Good morning.
Mansfield.
May it please the court, Brian Mansfield for the Commonwealth. The evidence of the dismissed charges were properly admitted into evidence under the Mazzarino case that allows for dismissed and/or null-prost charges to be before the jury. At no time did any of the facts, underlying facts of either the Hopedale offense or the Rhode Island offense, they were never presented to the jury. There was no testimony about them.
So let me interrupt, and you've only gone in for 35 seconds, to ask this question, because I think Attorney Bartman is 100% correct that each case we need to look at individually when we have this particular type of challenge, which is that the rules of evidence aren't exactly as uniform in these types of convictions, right? And so in a criminal case, the Corey would never come in, but in a sexually dangerous person's case, a Corey comes in. Okay. So I give you a hypothetical. Let's, in a hypothetical situation, the two charges are completely made up, and they're horrific charges and allegations of rape. And the prosecutor stands up in the criminal case and says, the victim completely made this up, Your Honor. We have a videotape and we've found proof positive. This didn't happen, okay? Later, there's a commitment hearing. Doesn't the judge, when determining whether the qualified examiner can base his or her opinion as to a diagnosis on a dismissed charge, have some role and responsibility, whether it's voir dire or otherwise, to have that gatekeeping responsibility? So just because something is dismissed, if there was an instance in which it was completely false, yet a qualified examiner considered dismissed charges and shouldn't have properly considered those in determining, for example, sexual sadism, doesn't the trial judge have to step in and take that gatekeeping role? And it didn't happen here.
Well, that wasn't the case in this case, that there was any evidence that these were made up. In fact, Mr. TOMASO didn't deny having sexual contact over a period of time with the woman in the Hopedale offenses. His statements have always been that they were consensual. So the fact that the victim had sex with Mr. TOMASO, or there was sexual contact between the two, was not in dispute.
But
So
ought there have been a voir dire to determine whether this evidence could be relied upon as part and parcel of a opinion and diagnosis and treatment?
as part of, maybe, so setting aside the admissibility based on Mazzarino of the charges themselves,
Right.
I believe they were independently admissible because the Commonwealth could have called either of the two victims. The victim in the Hopedale offense, I think what really happened was she was having some mental health issues around the time of when he pled guilty and the other charges were dismissed. The Rhode Island victim was unavailable. They couldn't find the Rhode Island victim at the time that it went to court. So that wasn't that he was, there was any suspicion or anything about his ability to testify other than that he was unavailable. So
I'm not sure I understand that rule. Like, if it's, the rule is, well, the Commonwealth could call the witnesses with direct knowledge of the offense, but doesn't.
Right.
That's enough to say, well, then the qualified examiners can rely on the facts.
And
I
under
mean, it doesn't
Markford-
quite make sense. Like, maybe the Commonwealth doesn't want to call them, but it still could theoretically. So why is that enough to, I understand that's what Mark Vart appears to say, but it doesn't
Right.
make a lot of sense to me, right? As opposed to what Justice Walsh is sort of saying, that the judge, assume that the judge has to make some kind of independent determination that this is reliable information that can be relied on. So can you just help me with that, understanding why that distinction is?
I mean, it goes back to the juvenile case, which Mark Vart cites, that when there is evidence that is independently admissible but not admitted, the expert can rely on it.
Yeah.
And in this case, the experts relied on the Hopedale and the Rhode Island cases in part to reach the diagnosis for sexual sadism, because he did have other sexual conduct that could have met the criteria, including his sexual conduct at the treatment center. He has about 4 or 5 disciplinary reports while incarcerated or while at the treatment center for exposing himself, for using sexual language, for masturbating in public. So those,
Yeah, but, oh, sorry.
No, go ahead. Go ahead.
I think Mr. Bartman's point is like, well, yeah, that's all bad, but it doesn't quite get you to sexual sadism, which is a diagnosis here. You really need kind of the underlying facts in the rape allegations to get there, and that notwithstanding all the other bad conduct, that's like the missing link here. So,
well, there is no dispute that Mr. TOMASO also suffered from a statutory personality disorder, which time and time again by both this court and the SJC has been found to be sufficient for a finding of sexual dangerousness. The qualified examiners and the Community Access Board representative both linked all of his sexual offending and the sexual offending that was convicted and before the court on his antisocial personality disorder, or his statutory personality disorder. It was what's known as an other specified personality disorder under the Diagnostic and Statistical Manual. So even without sexual sadism, the requisite mental condition was present, and all of the Commonwealth's witnesses linked all of his sexual behavior to the personality disorder. And that personality disorder, as Mr. Barton acknowledged, continues to be quite strong in the present. That was exhibited throughout his time at the treatment center, and it was exhibited at trial, particularly in his own testimony, where he attacked his own attorney, he verbally attacked his own expert, he attacked the whole, I mean, you can read the transcript, but so that personality disorder in and of itself was sufficient for a finding of sexual dangerousness. So even if we didn't have the sexual sadism disorder, or even if this court found that it was error to have the sexual sadism disorder, it wouldn't be reversible error because he had the requisite mental condition in the personality disorder, which the experts linked to, again, his prior behavior and his risk to reoffend in the future as a result of that personality disorder.
I mean, that one's a little bit hard in that, as usual in jury trials, we don't really know what the jury determined. But in a context such as this, sexual sadism as a diagnosis versus a not otherwise specified antisocial personality, it seems like the link is much stronger to risk and danger on the outside if you have been diagnosed, from a layperson's perspective, having the disease of sexual sadism versus a not otherwise specified antisocial behavior that then have to continue to link. So how you separate those two and say, well, no, just look at the antisocial, and the jury could have determined that he's should be civilly committed just as a result of that. I don't know how we can dissect the jury's verdict that way and
Well, I think just the
reduce
presence
prejudice.
of the antisocial personality, or the personality disorder, and it was the other specified personality disorder, which differs only from antisocial personality disorder because there was no evidence of a conduct disorder prior to the age of 15. There's just no records about Mr. Tomaso, or very few records about his age before 15. But any personality disorder or a personality orientation is a robust risk factor in the sexual recidivism research, and the jury heard that. And so the focus of the qualified examiners and the CAB representative, their testimony, their reports was on the antisocial personality, or the personality disorder. I'm sorry, I keep saying antisocial, but that was the focus, that was the link both to what caused and drove his offenses in the community and what really presented a risk in the future. Although they gave that testimony of sexual sadism, they didn't really get into it to any degree, except for there was some evidence that one of the qualified examiners asked him if he had a sexual interest in humiliating or pain of his victim, and his response was, it depends on the woman. So even to that extent, that comment alone was pretty damning for Mr. Tomaso, and with the other aspects could support, even without the Hopedale of the Rhode Island, could support that diagnosis. Because he did acknowledge the that he had, I mean, he didn't say, it wasn't an unqualified yes, but when you say it depends on the woman, then that shows that he does in fact think about pain and humiliation as a sexual interest that he has. So I think that is also very important when you're looking at the two diagnoses.
Could a qualified examiner have reached the sexual sadism diagnosis based just on the charges, not the underlying facts of those charges?
If the only evidence before them was the charges, no, but they had the other offenses, they had his conduct at the treatment center, which they linked to the sexual sadism disorder, and his own statement that I just discussed. So there was other evidence that they could link it on. Just based on the charges without knowing the underlying facts, you wouldn't be able to do that, without other facts, which I think were present here. The other issue that was presented by the appellant was on the static 99R, the risk labels, which the appellant cites the George case, which was the SJC case that said the prior old risk labels that were not associated or not mathematically tied in, those were inadmissible. The issues addressed by the SJC were actually addressed by the drafters of the static 99R, and they have changed, and they are now mathematically tied in, being average. The second issue he presented on that was the use of the 20-year risk labels. There was a case that came down, I believe, the day after Christmas, the Romanoff case, where this court found it was not error to, or was not, the judge did not abuse his discretion by allowing the 20-year risk labels. And even if it was error, even if it was an abuse of discretion, it didn't consist of reversible error. So unless the court has any other questions, the Commonwealth will rest on its brief.
Thank you. The matter is submitted.
Thank you.
All right, the next case is 25P0027, Commonwealth versus Torres. All right, good morning. Attorney DeMeo?
Good morning. May it please the Court. Christopher DeMeo for Jonathan Torres. I'll talk about the sufficiency of the evidence, and then hopefully I'll have time to talk a little bit about expert issues. I know the panel knows the facts, but I'll just tick off a couple of important ones that I'll be mentioning. So LP, the complainant, was born in 2003. The abuse was alleged to have happened in 08 or 09 when she was 5 or 6. The first complaint either happened in 2016, which is what she said, or 2014, which is what her mother testified. Although 2016 makes more sense because there was evidence of police interviews happening in 2017, shortly thereafter. So we're dealing with probably a 7 to 8 year delay, at best a 5 year delay, since the incident alleged to have occurred when she was really in her early childhood, when she was 5 or 6. And she had not seen Mr. Torres since 2009, so it was determined at a pretrial motion hearing that she could not identify him in court. So this case doesn't involve, an ID, and for that reason it doesn't involve, it's not a Santos type of case. The case this court decided a few years ago that holds that the word of a complainant is sufficient to convict, because if she had pointed at Mr. Torres and been able to say that that's the one who did it, then that would be a Santos case, and I wouldn't be here. So it was a circumstantial case that the attacker was Jonathan, and that my client had to be that Jonathan because of the circumstances. And then she went on to link his name Jonathan to another name, Montanez, a couple of times, really without any prompting, just on her own. But even setting that aside, before we get to the Montanez, I would submit it's a pretty weak circumstantial case to begin with, just based on Jonathan, because she testified that she never actually called him that, and she didn't recall what people in the household called the person that she's thinking of as her attacker. So, and this is a memory from early childhood. So that I would submit sort of teeters on the edge of Lattimore to begin with. But then we have this Montanez, which it's not simply just a misnomer, I would argue, as the Commonwealth argues in their brief, because it's a real person. If she had said Ramirez or, I meant Torres, I got the wrong name, that would be a different matter. But we know for a fact from the record that this is a real person who was LP's mother's boyfriend after my client was, and as far as I can tell, it was in the same approximate time frame. We don't know exactly when she started going out with Mr. Montanez, but
I mean,
Well, the victim's mother testified as well, right, at trial, and she provided additional testimony, talked about how she lived with the defendant during the time period that the victim alleged the abuse took place, correct?
that's true, yeah.
So there was, as you mentioned from the outset, there was circumstantial evidence, correct? It doesn't have to be, right, necessarily that for the jury to find beyond a reasonable doubt that the defendant was guilty, that there has to actually be the victim pointing him out in court and saying, yes, he's the one.
Well, that's true, yes. You can convict on circumstantial evidence, but I mean, the case we cite, the best case, the SJC says you can convict with a web of convincing proof or something to that extent. And I don't know that you have it here. If just I remember the person who did this to me was named Jonathan, and there was a person named Jonathan who lived at the house in the time frame, particularly. But then when you add in Mr. Montanez in the mix, because the evidence was that my client moved out in 09. They continued to live at this house, Layford Place, Layford Plaza, until 2011. So she was still there after Mr. Montanez moved out, and when there may have been when Mr. Montanez was in the mix. So yes, you can prove a case based on circumstantial evidence, but as I was arguing before, it's not much to begin with when you just have Jonathan and the fact she remembers this name and he was there. But when it's linked to this other person who was also there in the same approximate time frame when LP was pretty young, maybe not 5 or 6, but maybe 6 or 7, then you really have we're getting in the range of speculation, I would say, because, jurors are supposed to be able to, they make credibility determinations and things of that nature, but this was, again, purely circumstantial, and the inference has to be, well, it makes a lot more sense for me to pick, my client than somebody else, such as Mr. Montana's. And I'm submitting that when you look at the record, there's just not a lot there to pick from. Because of the way the Commonwealth tried the case, they indicted my client, so there's a lot of talk about Jonathan Torres this and Jonathan Torres moved out in 2009, but I can just as easily imagine what if it had gone the other way and they had indicted Mr. Montana. You could hear a lot of questions about, well, didn't they live at Layford Terrace until 2011, and didn't you have access to their, and didn't both the mother and grandmother continue to work, and there were certain periods where, there were no other adults home. So I can imagine it going the other way, and I'm just not seeing, I would submit when you look in this record, it necessarily involves some conjecture
We're reviewing this to the light most favorable to the Commonwealth, correct?
That's certainly true. But the other side of the Lattimore standard is it's not enough that there be some proof, however slight. So, and that's really what I'm arguing you're getting up against. When all you have is, I remember from the depths of my childhood that the person who did this to me was named Jonathan. I don't know why, because I never called him that, and no one else ever called him that. But there was this person named Jonathan who lived briefly at the house in this time frame. And that's already, as I said before, that's already a pretty weak circumstantial case. But when you throw in sua sponte, this Montana's into the mix, and we know for a fact he's actually a real person, then I would submit you, it really is, it is slight, it is too slight, even under the Lattimore standard. It necessarily involves some conjecture. It's not the web of convincing proof that you need when you're going to try this kind of case on circumstantial evidence. So, yeah, those are the main points I wanted to make on sufficiency. So I'll talk about experts unless the court has any questions. So my argument on the expert is that Professor Block exceeded what the SJC has allowed for this sort of testimony about the credibility or the behavior and disclosure pattern of children. Now, this is, I've made the same argument before with a couple of different panels without success, so I'll disclose that. But as far as I know, there's no published opinion that goes against me, so I'm going to keep pressing the point because it seems to me that when you read the key SJC cases, which I believe are Ianello in 1987, Dockham in 1989, and Montanino in 1991. This testimony that she gives is not acceptable under those cases. Now, Dockham certainly allows for the general characteristics of sexually abused children to be explained by an expert. And so if Dr. Block had limited her testimony to saying something like, well, sometimes children don't disclose immediately because they're scared or they don't realize what happened to them is bad, something to that effect, and she left it at that, that would probably be acceptable under Dockham. But that's not what she does in this case and in other cases. What she does in this case and other cases is she's asked to testify about disclosure patterns, and then she goes on to say that they are a person who's been sexually abused can never disclose, disclose immediately, disclose some point later, delayed, can recant or not recant. So what she's saying basically is that all behavior is consistent with a truthful account of sexual abuse. And this is really the objection that defense counsel made before the hearing, which is it's too general to be helpful to the jury who's supposed to make credibility decisions. And because it involves credibility and the truthfulness, it brings into play those three cases, Ianello, Dockham and Montanino. In Ianello, and I would submit Dockham has to be read in light of the other two cases. In Ianello, somebody, the defendant wanted to put on a witness who would say that children whose parents are going through divorce proceedings are more likely to lie or to manufacture sexual abuse claims. And the SJC said you can't do that because it covers a whole class of people, which is going to include the particular child at issue here, because the parents in that particular case were going through divorce. In the Montanino case, the government was the proponent of the expert, and it was a police officer who testified that generally when you investigate a sexual assault case, you get piecemeal disclosure. That happens most of the time. And the SJC particularly took umbrage at that phrase, most of the time, because they knew that that was what had happened in that particular case. And so even though the police officer expert didn't identify the witness and say, you know, this, and it applies to this complainant too, they said that's the obvious inference that the jury's going to make. So when the testimony as to disclosure patterns or the credibility of the witnesses applies automatically in every case, I would submit it's improper. I mean, it's improper because, as defense counsel said, it's just not helpful to the jury who decides credibility. And that goes way back to the SJC's Francis case, which we cite. But it's also improper under the Ianello, Dockham, Montanino line of cases, because it's just a way to you know, I mean, the reason the Commonwealth uses Professor Block in all these cases is because they can always bring her in and she can give the same testimony. It will always apply. I assume that when
I mean, she's kind of locked into having to give the same testimony in every case because you're not allowed to sort of gear your testimony towards the facts of this. You're supposed to be general, right?
That's true.
I totally take your point that how useful is her testimony when it's sort of validating every type of disclosure, but the case law does require that it be presented in general terms, not in specific terms, right? Because that would be unfair to the defendant as well.
Well, it's true. I mean, there's a Tanner issue when you have I guess the Tanner is the case where you have an expert who's also a fact witness and
Yeah.
who says, I talked to this person, and yeah, so that would be problematic as well. But I guess my point is,
But can I, and let me just interrupt for a moment. I guess because it's behavioral, it seems like you're almost have a different standard. So Dr. Block is testifying about delayed disclosure and why children in particular might wait a long time. And then when they do, how that disclosure is made. But how is that any different than an expert who opines about back pain? It could be this, it could be that, it could be present this way, it could present that way. It's a medical opinion that provides a kind of laundry list, if you will, or a wide spectrum of ways in which harm is presented.
because it covers everything, I would submit, it's not helpful, because it will inevitably apply in every case. It falls under the ambit of those cases that I just mentioned. I don't think it's like a doctor. I mean, the doctor will say,
It is a doctor.
a doctor, I would think, would say certain things, rule out whatever is being the proponent, the plaintiff says, and she's not ruling out anything. It's more to me, I think, like if you brought in a police officer witness in a search and seizure case, and he says, I know when I pull people over and they won't make eye contact with me, that's a sign they're nervous and they've got something in their car. And sometimes people who have contraband in their car will look at me and make excessive eye contact because they want to get the stop over. And sometimes they'll fumble around for their license because they're nervous, and other times they'll have their license ready, and that also shows they have contraband in their car. That doesn't tell you anything. I mean, that tells you that the cop thinks that most people have contraband in their car, but the question is, did the witness in that case? And the question here is, did LP, in fact, was she behaving credibly? And because it covers everything, it's not helpful. It's true, we only see the case. I assume when there's cases with immediate disclosure, they don't bring in Dr. Block, but they have her sort of as a backstop in all the other cases, and that's why we see this. I'm about out of time. For the reasons in the first part of my argument, I would submit this was a pretty weak case, so this was objected to, and it could have affected the verdict. Thank you.
Thank you for your argument. Attorney Nichols.
Thank you, Your Honor. Christopher Nichols with the Hampden County District Attorney's Office. Good morning, Your Honors. May it please the Court. Commonwealth would just kind of follow the track that my brother followed during his argument, starting first with the sufficiency claim and then discussing the Commonwealth's expert evidence. Going to the sufficiency claim about the identification, the Commonwealth concedes that this was a circumstantial evidence case. We have a victim who wasn't allowed to identify the defendant in court, and the Commonwealth tied or closed that open question with testimony from the victim's mother, as Justice Tan pointed out. And what the victim testified to was that she had been sexually assaulted by a man who she generally knew as Jonathan, and but didn't remember a specific name, that they had lived together at a specific address during a specific time frame at a specific age, ranging for several years, with her mother, her siblings, and her grandmother, and didn't make an in-court identification. The Commonwealth then calls the victim's mother, and the victim's mother says, around the time frame that the victim had just described, in this particular house with these particular people, this was my boyfriend at the time, the defendant, and that left the jury with the ability to conclude that it was the defendant who was the person who committed the sexual assaults against the victim, in the way that she had described. So through that circumstantial evidence, the Commonwealth was able to prove identification beyond a reasonable doubt. This isn't the defense counsel does make a large, many claims about the fact that the victim misstated the defendant's name during her testimony, setting aside the fact, of course, that she wasn't allowed to make an in-court identification of him anyway. But the fact that she uttered a name that wasn't attributable to the defendant isn't enough to suggest that the
Well, it's a little more than that, right? It's a kind of unusual case where the victim testifies the first name of one of the mother's boyfriends and the last name of another of the mother's boyfriends, and who was the boyfriend in the same general time frame, right? So it's a little bit more than just misidentifying the name. It's kind of combining two different people, and I would assume that the defendant's argument is sort of like, if you have a case where it's not really clear which of two people was the offender, is that enough to sort of get you past the sufficiency requirements of Lattimore?
Yes, Your Honor, and the reason is because in the cases where there's potentially two perpetrators and the court says there's just not enough evidence for one to be identified over the other, I think defense counsel cites, I believe it's Salem. And in that case, it was a situation in which there was three people at a table, two people sitting across from the victim. The victim gets shot. There's testimony from, I believe, the waiter who leaves, and then 10 minutes later he hears a bang, comes out, and then the victim is dead. And it could have been either of the two men across from the victim who shot him. And the court said that there wasn't enough evidence for the jury to conclude that it was one over the other. But this isn't that case. Yes, the victim's mother has had other boyfriends other than the defendant, but we're talking about an identification made not only from a name and an association, i.e. the mother's boyfriend, but also a place. The house in Springfield where the victim lived with her grandmother and her mother and the children of the defendant. The child that was born between the mother and the defendant was J.R. And there's testimony about how he was born in that house, and she remembers those interactions, and the mother kind of also corroborated that testimony. It is the father of J.R., i.e. the defendant, who was the one who sexually assaulted the victim. This isn't, there's two men in the home who, either of whom could have assaulted the victim in the way that she was. There's one man in the home, one adult man at this home with this victim and with the other members of the household. The testimony was that this came from the victim and the mother, I believe, but that this was a person who, the man was, actually, strike that, it was from the mother. The defendant was unemployed. He was living in the home. He was the caretaker of the children when the mother and the grandmother were out working as nurses, I believe. And it was he who had access to the victim. It was he who was responsible for taking care of the children at this home in the absence of the other adults. And it was therefore very clear that the jury could reach the conclusion that it was, in fact, the defendant. The fact that there are other men on planet Earth who could have potentially caused harm to these children is mere conjecture. It was definitively the defendant, and that was proved circumstantially through the evidence through the testimony of the victim, and then shored up with the testimony of the mother. If the court
Can you address the issue that the opposing counsel brought up about how Dr. Block's testimony is really basically anything goes, right? All patterns of disclosure are consistent with abuse.
Well, I think that Justice Walsh characterized the testimony in a way that it may be more accurate to what that testimony is. It's not an umbrella that's meant to catch everything that's under, that falls under it. It's essentially medical testimony. It's testimony about a psychological phenomenon that happens when people suffer or children suffer sexual abuse, which is that they may delay their disclosure. And the parameters of that kind of testimony have been laid out in the case law, including Deloney and Dockham. And I think it was actually specifically Dockham that talks about the kind of difficulty that exists, admittedly, with this kind of testimony, which is that it can't be so specific that it's improper vouching, but it can't be so general that it's not relevant. But nonetheless, it is the Commonwealth's prerogative to educate jurors about issues and topics that they might not have any idea about, or may even come into a courtroom with misconceptions about or misperceptions about. The idea that, well, of course, a victim of a sexual assault who's a child would immediately tell their parent, or some other kind of presupposition like that. The purpose of this expert testimony is to explain, no, children who have suffered sexual assault may in fact not tell their mother or their grandmother or their friend or their teacher, and that kind of thing may come out later. And it happens in various forms. If Dr. Block had testified about, more specifically, about different types of delayed disclosure that matched the type of delayed disclosure we had in this case, then the argument would be that it is definitively improper vouching in the way that I think kind of came out in the Monte Calvo case, which I think defense counsel cites too many times. And I just want to distinguish, the Montanino case. And the reason why I bring that up is that it's distinguishable from the fact pattern here. In Montanino, there was a sergeant, and the sergeant testified that he had interviewed, I think, over 300 people about sexual assaults, and that his experience was that he'd have to do interview after interview after interview with these victims, and each time he would learn something new about the case. It was also, that sergeant had also interviewed the victim in the case that he was testifying to about when that case was argued. And so we have a police officer who's talking about his vast experience doing sexual assault investigations, a person who had interviewed the victim in that case, and then kind of overlaying his general knowledge about how he conducts these investigations onto the fact pattern of that case. And the court said that was inappropriate. That's why the conviction in Montanino didn't stand. But that's not what we have here. We have an expert in the field talking about a psychological phenomenon in an objective way and in an honest way. And
is there can you give me any factual scenario where Dr. Block's testimony, if given as it was here, would not tend to support or bolster the testimony of the alleged victim?
Yes, and I think actually this case maybe even stands for that proposition, and here's how. If Dr. Block's testimony is as broad as being suggested by the defendant, which is that basically any kind of iteration of delayed disclosure is characteristic of what a delayed disclosure could be or looks like, then defense counsel, and I think defense counsel did that in this case, can select those types of delayed disclosures which don't fit the fact pattern in the instant case and say, well, ladies and gentlemen of the jury, this, you heard from the Commonwealth's expert that delayed disclosures sometimes look like this, but that's not what it looked like in this case.
Right. So there are certain scenarios that she testified that didn't fit this pattern.
Right.
But is she excluding anything? That's my question. Like, does her testimony sort of actually say, oh, when this happens, when this kind of disclosure, actually you shouldn't be likely to believe that, right? Is there anything does it leave out?
It is the case that we didn't do. I don't think there weren't any questions directed to the expert in which she was asked to make those kinds of distinctions.
Yeah.
But I also think it would be problematic to kind of ask her to do that if it is not the case that there is a type of delayed disclosure which doesn't fit under the ambit of like what they generally look like or how they could look like. In other words, I don't think it would be appropriate to ask Dr. Block to incorrectly testify about how delayed disclosures occur in order to
No, I'm just asking if, what's the purpose of this testimony? I mean, to Justice Walsh's example, the doctor's testimony about what causes back pain, presumably the doctor, she's going to say, well, these things can, but these things can't, right? And there's no these things can't here as far as I can tell. It's just sort of everything in some way can fit the disclosure as it happens.
Right, but also...
How useful is that to anybody? How useful is that to a finder of fact?
Well, again, Your Honor, I think that the purpose of her testimony is to describe like a psychological phenomenon, something that's objective and then an expert can testify about.
But I understand that, but this specific case wasn't really about, do you believe the victim? So I understand the Commonwealth can try a case and the Commonwealth can put an expert, even if you may say, why are we educating the jury about something that's not before the court in this particular case? But the expert here testified about memory lapses, which there were none, and about repressed memories, which I didn't see, but maybe I missed it in reading the transcript. And so I guess on cross-examination, right, of Dr. Block, defense counsel could say, aren't you aware, Dr. Block, that there are a number of instances in behavior that would indicate the victim is not either memory is accurate or is not necessarily telling the truth, correct? I guess there's always the escape route of cross-examination, but I guess I'm not really sure why Dr. Block would testify about repressed memories and memory lapses when this case had nothing to do with that. And so it's a super broad kind of everything could be something.
Yes, Your Honor, I guess on the topic of memory specifically, which is kind of a separate issue from the topic of delayed disclosures, I would just note to the court that Dr. Block's testimony about memory was very limited. It was just a few questions, and she just testified generally about the parameters of memory. I would also note that the issue of memory is something that is at issue kind of inherently in every case, because we have people who are testifying about things that happened in the past. Necessarily memory is implicated, and the accuracy of their testimony is implicated in the sense that their credibility is always at issue. And so I don't think that Dr. Block testified to anything that was inappropriate. She spoke, as I said, very generally about memory, touched on it, and then it sort of ended. And as I noted in my brief, the judge made it very clear to the jury that they were the sole deciders about credibility. They were the ones who were assess whether or not a witness appeared to have a good memory about things or didn't, and how to judge that person's credibility. The Commonwealth didn't overemphasize memory in its closing arguments to the jury. And so even if the court thought that Dr. Block's testimony about memory simply shouldn't have been part of the record, I would suggest that there was no prejudice to the defendant from it. And I do think that it's, again, just to go back to the delayed disclosure testimony, I do think it's important to just emphasize that this is a scientific type of testimony, something that a layperson wouldn't be able to testify to, and it is to educate jurors about maybe about things that they wouldn't have necessarily known on their own, which is how people who have suffered sexual assaults might, at some point, describe what had happened to them in the future. And that's something that the Commonwealth, I think, has an interest in making sure that the jurors know in these types of cases. Just to touch lastly on the defense counsel's motion for new trial arguments, I would note that the judge who oversaw the trial is also the judge who heard the motion for new trial, and and his findings are of deference, and among those findings are that defense counsel did render effective assistance, and that the purported expert from the defense counsel on the motion for new trial likely wouldn't have added anything to the defense.
All right, thank you. The case is submitted. All right. Our third case is Commonwealth versus NASCIMENTO, docket 25P0328. Attorney Arter? Thank you.
Good morning, Your Honors. Corey Arter for Joseph Nascimento. This is an appeal of Mr. Nascimento's conviction of resisting arrest and assault and battery of a police officer out of the New Bedford District Court. As Your Honors are aware, I raised two main issues on appeal, first being whether or not there was sufficient evidence to convict him of resisting arrest, where there was insufficient evidence that he knew he was being placed under arrest, and whether or not his actions of fleeing and rolling up into a fetal position were substantial enough to create a risk of bodily harm. Second argument, obviously, is self-defense argument, whether or not there was sufficient evidence to convict him of assault and battery of a police officer, where the evidence was that he was acting in self-defense to the excessive force being used by the officers. Just briefly, if Your Honors would permit, some facts that I think are fairly important to my argument. It's undisputed that Mr. Nascimento's ex-girlfriend applied for and was granted a restraining order on July 12th, 2023. On the date of this incident, some 10 days later, evidence is clear and I think conceded that Mr. Nascimento had not been informed of this. He did not appear in court. He was not aware that there was any warrant out for him. The two officers who testified, Boulay and Pacheco, both testified that they received a call to respond to Kempton Street in New Bedford. When they arrived, they saw a gentleman walking out of a liquor store holding a bag, and two officers attempting to talk to him. By all accounts, at this point, Mr. Nascimento is slowly walking away from the officers. At some point, somebody hears him use an expletive, FU, no, and then continues to walk away and eventually begins to run. Detective Boulay testifies that he's the first one to give chase. He chases after Mr. Nascimento, tackles him, gets on top of him, is holding him down, pulling his arms and restraining him. 6 other officers then immediately thereafter arrive on the scene and also get on top of Mr. Nascimento. He is pepper sprayed, he is tased twice, he is kicked, he is punched, and we've seen the video. At this point, sometime during what is described as a several-second interaction, very quick, Boulay says, oh, it's at that point that I say, hey, you're under arrest for an outstanding warrant. The issue of the timing becomes important as to when this alleged resisting arrest occurs. Clearly, there's no evidence he was advised at the time he's leaving the liquor store and before he begins to flee, which we know is not resisting. He wasn't advised at that point. So the next point you get to is the point where he's already been tackled. 6 police officers are on top of him. He's pepper sprayed.
Was there testimony that when Officer Boulay grabbed him by the biceps, he said, "You're under arrest"?
There's testimony, and my reading of the testimony is it's not clear. He testifies that when he's on the ground, after he tackles him, when he's trying to grab his arms, and at this point, all of the other officers are descending on the scene, it's at that point that he says to him, you're under arrest for...
But not when he grabs him by the bicep.
Not when he's up, after he tackles him. And my Detective Boulet's testimony is, I'm the first to catch up with him. I then tackle him and I take him down to the ground. I am on top of him. Pacheco testifies that at this point he comes upon the scene. The other officers come upon the scene. They're same there. So in a matter of seconds, when all of this is happening and the 6 officers are there and they're descending on top of him, at that point, while he's on the ground in a fetal position, and we have the benefit of this bystander video, it's at that point that somebody allegedly says to him, you're under arrest for a warrant.
I think it was Boulet, right? Boulet testifies to that,
Yes.
right? But then after he says that, and it sounds like it was a bit of a melee,
Sure,
right, throughout.
absolutely.
But once he says you're under arrest, he testifies, Boulet does, that the defendant continues to move around, he won't pull his arms out, he's kicking, elbowing, throwing hands, and I'm reading from page 136 of the second day of the trial transcript. And that's when they had to tase him, and they did that, I think, twice, right? It didn't work, and that's when they pulled out the pepper spray. So there continued to be, and I concede that, I understand that it's unclear up to the point that Boulet testified that he tells him you're under arrest. We don't know. And he testifies, I don't know what was said prior to that when the other officers had been
Absolutely.
with the defendant, right? But at that point, once he tells the defendant you're under arrest, there is testimony and evidence, right, that the jury could have credited that the defendant continued to act in a way that was, consistent with sufficient evidence of finding that he resisted arrest, correct?
And with regard to that, and again, crime of resisting arrest occurs at the time of effecting the arrest. Still goes back to basic Grant. Got to show that the defendant has knowledge or understands, or a reasonable person would have understood that he was under arrest. At this point, despite the fact that no one explains to him why they are initially following him, nobody says anything to him at the liquor store, no evidence whatsoever, he knows what's going on, other than he's being chased, he's being tackled, he's down on the ground. Now all of a sudden 6 officers are on top of him. Even if you believe at that point, sometime during this whole struggle, which again is a matter of seconds according to Boulet, somebody then says it. This struggle is already taking place. He's in a fetal position. He's got his arms here. He doesn't understand what's going on. He doesn't understand why they were chasing him.
But you don't need an explanation why you don't need to, here's what's going on. Here's the reason we're doing. If an officer says you're under arrest, that triggers under Granderson the obligation not to resist, right? In those circumstances, I guess.
Again, resisting arrest doesn't occur if you have, on fleeing. And if you don't know, it doesn't occur on a threshold inquiry. It doesn't occur, even if you're on the ground being held in position. That's fleeing. You're deemed to have backed off and fleeing. And again, that goes to the self-defense.
No, there definitely are cases that say you can't you can't assume that the defendant understands that he or she is under arrest because of the circumstances.
Yes.
But I don't think there are cases where the officer says you're under arrest, and that's not enough to.
Yeah. And then I would point to the video evidence and the testimony of all the officers as to how this went down and how many officers were there in the struggle.
Well, certainly we can look at and have looked at the video.
Yep.
The standard that we employ is in the light most favorable of the Commonwealth, correct?
Absolutely.
Okay. And so tell me why your argument still succeeds. That's the trickier part, right? Not before the jury, which is tricky in a different way, but the tricky legal part here is that in the light most favorable to the Commonwealth, there is a transcript in which Officer Boulet says, "He told me he was under arrest," and what did he do immediately after? And I'm on page 117. He began kicking, pushing, and punching, right? So despite testimony, light most favorable to the Commonwealth, whether you say, well, there's lots of going on.
Sure.
That's good for the jury. But for this panel of appellate court justices, when we see the testimony that says, I told him he was under arrest, and he kicked, and he pushed, and he punched. Tell me why it's still insufficient as a matter of law.
And again, I would point to his knowing and his understanding, and I understand that Boulay said that, and with regard to that, certainly doesn't know when he's fleeing, certainly doesn't know before he's being tackled, certainly doesn't know when a melee is happening, and the video evidence is it's loud, there's lots of people on top of him, there's lots of yelling back and forth. I would suggest that it goes to his knowledge or understanding as to why he's on the ground at the first place, being attacked by 6 or 7 police officers. So again, I would say it goes to knowledge on his part, whether he understands. And I do understand that there is testimony of Boulay, and I do understand that in the light most favorable to the Commonwealth, if you believe that there were not these other circumstances going on, and this was not such a brutal, essentially, attack and takedown of this man.
Even if, respectfully,
Yeah.
all of that happened, once a police officer says, you're under arrest, the law says that unless there's excessive force, you're to comply, right? You're not to kick, fight, punch back, right?
Or bite.
So, which brings me to my next argument with regard to the excessive force, and unless there's excessive force. And in this case, Mr. NASCIMENTO was justified in using what force he did or resistance that he did in face of the clear excessive force being used by the officers here. In determining whether or not he's justified in using non-deadly force, this court has got to look at whether or not, he made an effort to flee. He did. He fled the scene. He walked away. And in fact, under Eberly, he's pinned down and unable to flee. He meets that burden. So, he did attempt to withdraw himself from the scene. And while admittedly his right to defend himself is modified when you're dealing with a police officer, as here, when an officer or several officers are using excessive force against him, he's still allowed to use force to defend himself. Even in cases where initially there's no excessive force being used. At the point when the officers begin to use the excessive force, he is entitled to use such reasonable force that he seems necessary in order to protect himself. There's no evidence that NASCIMENTO intended to use force against the officer. Any activity or action by him in response to the excessive force was done as a defensive mechanism that was incidental to the struggle. The Commonwealth has to show that his actions were such that they created a substantial risk and that he was unjustified in using them in response to the evidence. Obviously, we have the quite disturbing video evidence of this incident, which clearly shows him on the ground. 7 police officers, 6 on top of him kneeling, 1 kicking him, 1 punching him in the face. Boulay admits, I punched him in the face, and his injuries that are shown in those photographs are from me punching him in the face. At that point, on the ground, being held down by 6 officers, being kicked, being punched in the face, defending himself, he is clearly entitled to use such reasonable force. The 2 alleged incidents of assault by Boulay would be the alleged biting of the hand and then the alleged kicking that happens in the ambulance. With regard to the biting of the hand, in this case, while he's on the ground, all these officers are on top of him, he's being kicked, he's being punched. Officer reaches in and tries to grab his hands or his arms, which he's in a fetal position on the ground. It's at that point that this alleged biting takes place. I would suggest that action incidental to the struggle was not an intent for him to harm this officer, but was in self-defense. With regard to the alleged movement of the foot or the contact of the foot to the officer in the ambulance, it is at that point, while he's being rendered care for being pepper sprayed in his eyes and being tased twice and still being held down by 4 officers on a gurney, that his foot allegedly hits Boulay in the mouth. Again, I would suggest that those actions are incidental to the struggle and follow the excessive use of force by the officers. Therefore, there was insufficient evidence, and the Commonwealth was required to prove that he was not acting in self-defense and that the officers did not use excessive force, and I would suggest that they have not. It did not at the time of trial. Therefore, his conviction was based on insufficient evidence and should be overturned. Thank you.
Thank you.
Thank you.
Morning. May it please the court, Jennifer Thompson for the Commonwealth, Bristol County. Just to address the two issues brought by my sister, here there was sufficient evidence to go with the jury of resisting arrest. The Officer Boulay testified that he had the intent to arrest the defendant. He knew the defendant had warrants outstanding other than the restraining order. And I suggest that it's inconsequential that the restraining order charge was ultimately dismissed because Officer Boulay had the intent based on the warrants itself and his knowledge that the restraining order violation had occurred that day.
When was the arrest effected? I think in your brief you mentioned grabbing the biceps. Your sister says, no, it's when he was, well, she just didn't say that, but that there was testimony when the defendant was taken to the ground. So when exactly would you put the affecting?
I'd suggest that once the defendant was brought to the ground,
Okay.
tackled to the ground, that's when the arrest occurred. And the officer indicated that immediately the defendant was struggling with Officer Boulay once he took him to the ground. During that struggle, Officer Boulay was attempting to get the defendant's arms, grabbed his bicep, told him he was under arrest for the warrants. So there was clear testimony of Officer Boulay that he advised the defendant he was arresting him on the warrants at that time.
Why take the defendant to the ground before telling him that he's under arrest?
Well, without knowing what the other officers stated, we don't know if he had been advised. However, the defendant immediately started running. Officer Boulay came upon him when he was running from the officer. So I'd suggest that within 50 to 100 feet, he was able to tackle the defendant, and he must, without surmising why he didn't yell to him, "You're under arrest," the tackle and the subsequent falling to the ground and wrestling with the defendant, he told him then. So again, I can't answer why he would have or wouldn't have. I don't know whether he did, or if anybody advised the defendant of his arrest prior to being tackled to the ground. But I'd suggest that, again, tackling to the ground isn't excessive force. In this case, I did cite some cases in my brief that indicated that the tackling to the ground in order to effectuate an arrest is not excessive force. So here, again, we had the intent. Officer Boulay said he had the intent to arrest the defendant. That intent was conveyed to the defendant, and after that intent to arrest the defendant was conveyed to him, the defendant continued to resist the arrest by continually struggling with the officers, keeping his arms underneath him, hitting and striking at the officers, and eventually biting Officer Boulay when he was trying to take his other arm and place it into a handcuff. So I'd suggest to you that there is no error in the denial of the motion for required finding, nor was it error for the jury or to find the defendant guilty, because under the Lattimore standard, there was enough for the jury to consider the elements of the resisting arrest. I also added in my brief that even if the defendant hadn't been advised by Officer Boulay that he was under arrest, the inference could be made once he was tackled to the ground and the officers were trying to get his arms. That is enough for the defendant to objectively know, or a person in the defendant's position would know that at that point they were under arrest. To address the defendant's claim that the defendant didn't act in a way that created a substantial risk of injury to the officers, I'd suggest that his actions of the struggling, hitting, kicking, and biting at the officers certainly arose to placing the officers in danger of an injury, and it also satisfies the other prong of resisting arrest, because his physical resistance, even pulling his arms away, was enough for the resistance. And finally, the argument that there was insufficient evidence to support a conviction of assault and battery on Officer Boulay. I believe that Officer Boulay, the assault and battery dangerous weapon in the ambulance, was not guilty. So the argument would be toward the biting of Officer Boulay during the struggle in the attempt to place handcuffs on the defendant and get his arms out from underneath him. the defendant suggests that there was some evidence of self-defense because the police used excessive force. In this instance, I'd suggest that the jury it was a question of fact for the jury to determine whether it was self-defense, whether or not the police used excessive force in this case. The judge appropriately gave the instructions because the defense rose the defense of self-defense. So the judge properly gave those instructions. The jury were entitled to consider the defendant's claim. Obviously, they weren't convinced of the fact that the defendant acted in self-defense, nor were they convinced that the police used excessive force in this particular case. And again, it was within the jury's province to do so. And again, I'd suggest that sending that charge to the jury was perfectly within the court's right, given the fact that she gave the jury instructions to the jury. Are there any questions by the panel? Seeing there are no questions, I will rest on my brief. Thank you.
Thank you. The matter is submitted. At this point in time, we'll take a brief recess and we'll address the next 3 cases once we return.
All rise.
All right, thank you. We're back on the record on docket number 24P1113. I've done an okay job pronouncing names, but I want to make sure I'm pronouncing NESBEDA versus Tucker, Clark, Moore, and others. Counsel.
If it please the court, my name is Elsa Diaz Alonso, and I want to begin by clarifying something, which is to say that my references to the Florida statute in my documents is not to suggest that this court follows Florida law, inasmuch as it was to say that because of the uniformity of Massachusetts and Florida law, that both turn to the location of where the trustee is.
Can you
Could
turn
you
the
speak up a
microphone
little
to a little
bit?
bit?
I'm sorry.
Could you just put the microphone a little bit closer
I
to you?
have a sore throat. I apologize.
Oh, okay.
I'm so
If
sorry.
you just move the microphone towards you, it might,
Sure,
yeah,
sure.
that'd be better. So you don't think Florida law applies to where the principal place of administration is, or you do?
No, I think that Massachusetts law applies.
Because, but it's a great question. I mean, one thing I'm really interested in, because the trust says, as restated, we're going to interpret this trust according to Florida law. So why wouldn't we look to Florida law to determine where the principal place of administration is?
Because for a principal place of administration, we look to the acts of, in any given state, what were the parties doing? What is the place of administration? That's to be distinguished from what is a choice of law. So you can have a choice of law in one jurisdiction, and you can have a place of administration in another jurisdiction, which is exactly what happened here.
But wasn't everything,
Yes.
wasn't everything basically based out of Florida? I mean, the decedent moved to Florida in 1987. She hadn't visited Massachusetts in the last 19 years of her life. Meetings about the trust were, took place in Florida, correct? And there was language after, I think it was in 2016 when there was an amendment to the trust that any reference to Massachusetts was taken out. And in fact, there was language, right, that all matters involving the validity and interpretation of the trust were to be governed by Florida law. So wasn't everything, sort of didn't all signs and of intent and activity and administration, everything, wasn't it all pointing towards Florida?
No. And the reason that it doesn't all point to Florida is first of all, you look at the 1987 trust that for 29 years had Massachusetts as a choice of law and the place of trust administration.
No, the trust didn't say that. It didn't say the place of administration.
Yes, I'm sorry, Your Honor. This is the 1987 trust.
The 1987 trust said that it would be
Administered.
the trust would be construed, governed, and administered in accordance with Massachusetts law. It did not say that the place of administration would be Massachusetts, right? I mean, so is there something else? Is there some other provision of the 87 trust agreement that I'm missing?
No, I interpret that to mean that the place of trust administration, she intended it to be Massachusetts.
Why? Why does the provision that sort of says it should be
because she
construed in
says so.
accordance, why does that establish the place of administration? Those are different issues.
Yes, it establishes the place of trust administration because that's what she says in the trust. That it's going to be construed.
Saying that a trust shall be construed according to Massachusetts law doesn't mean that the place of administration is Massachusetts. Those are just different issues.
Bear with me and I'll pull out the language.
It's on page 66 of the record appendix. And this provision was taken out when their trust was restated. That's a different issue, but
That's a separate issue.
okay.
So can we back up for a moment? Because I appreciate your candor at the very beginning of the hearing, but in my mind, what law controls doesn't matter in as much as if Massachusetts courts doesn't have subject matter jurisdiction. You got to get over subject matter jurisdiction before you got to decide whether it's Mass law or Florida law that's applied, correct?
Correct.
Okay. And so we had a revocable trust, it got changed, and the judge dismissed under 12B1, which we reviewed de novo. We're in agreement so far?
Yes.
Okay.
It was revocable until the settler died.
Right.
And
And
then
so,
it became irrevocable.
so the judge decided that there was no subject matter jurisdiction, right? And you say that the judge,
The judge decided that there was no subject matter jurisdiction because she found that the defendants had objected to jurisdiction.
right?
And she used some facts to say that Mary had her connections, she spoke about the connections that Mary had to Florida and to Massachusetts.
So just so that I understand, so if it's something that's all in Massachusetts, no issue about subject matter jurisdiction. We have an individual who has passed in Florida, has ties in Florida, that has an administration of the trust in Florida, correct? And your client comes in to say, I want this determined here in Massachusetts, and the parties object. And so tell me where the judge got it wrong in saying, as Justice Tan said, on the subject matter jurisdiction issue, all roads lead to where it's about 50 degrees warmer than it is right now. I mean, tell me why. I just don't see.
No doubt. Yes, I believe that Mary intended for the trust to be administered in Massachusetts. I maintain that those are the facts. There was a dispute between the trustee who is here in Massachusetts and the plaintiff who is also here in Massachusetts in terms of Mary's connections to Massachusetts. But I believe that Mary intended, as the facts show, for the trust to be administered in Massachusetts, not Florida. And that she did not change that provision until much later on.
But, okay, so you're relying on the provision in the original 87 trust agreement that said this shall be construed according to Massachusetts law. And that was removed when the trust was restated.
Well,
So
I'm also-
doesn't that cut against your argument that this provision you're relying on was taken out of the trust?
No, because I think that for Mary, there was a continuum of where she wanted this trust to be administered. And again, we have to really look at the facts. What happened here? In fact, what were the acts? Well, the acts were that the trust was administered here in Massachusetts.
But why would she remove the language? Why would she remove the language that,
You're saying that she removed the language of place of trust administration.
Right, because you're relying on the language in 1987 that says that the trust should be administered in Massachusetts, and that language is no longer there after the 2016.
And I'm
So-
also relying on the actions that took place post-death, that the trust was actually administered here in Massachusetts, and that the trustee is here in Massachusetts, and that is the law. Under Walton v. Harris, the court there decided that because a trustee was in Massachusetts, that the court had subject matter jurisdiction to hear the case in Massachusetts. And so I'm relying on the connections that happened post-death. That post-death, the distributions of the trust took place in Massachusetts, although the distributions are not complete as of this date. But nonetheless, you got the trustee here in Massachusetts. You have the administration taking place here in Massachusetts. Massachusetts then becomes the operational base for the trust. The records are kept in Massachusetts.
Where does it say the records are kept in Massachusetts?
In our facts.
What facts?
The facts that we submitted in the complaint in, it's part of the records that the, it's part of the record that the records are kept in Massachusetts.
Did the judge find that?
Well,
I mean, the
the
judge
judge's
found,
findings of facts were very limited.
the judge found that Mary established the trust after she moved to Florida in 1987. She resided in Florida until her death. She held meetings about the trust in Florida. All trust expenses were paid from Florida. Much of the trust assets were Florida real estate. All of Mary's estate planning concerning the trust was done in Florida. Why wouldn't we consider her residence in Florida to be kind of the place of business of the trust, given all those?
What the judge didn't reach was what impact does it have for the trustee to be located in Massachusetts? And under the Massachusetts statute, where the trustee is located, where the assets are located.
Which trustee are you talking about? There's three. Which one?
Hannah.
Hannah.
Hannah, the defendant.
Okay, but Mary was a trustee, and
She died.
okay, but while the trust was in existence, she was a trustee all
While
throughout.
the trust was in existence, she dies. Once she dies, the trust becomes irrevocable. The successor trustees take over, and Hannah lives here in Marion, Massachusetts. So part of the Massachusetts law is that you look to the trustee, you look to the assets, where are they located? In Massachusetts.
But the trust effectively terminated upon Mary's death. It was just all that remained at that point was the distribution of its assets to the beneficiaries, right? It's not like it became a new trust
Well, on
then.
termination of Mary's death, the trust becomes irrevocable.
Okay, but
That's
is
what
your,
happens
is
to
your
the
position that
trust.
the place of administration changed when Mary died, that it was in Florida before and then it moved to?
No, that's not my position. My position is that all along, Mary intended for Massachusetts to be the place of trust administration. We also, that's our position.
Okay.
And my position is also is that the lower court judge didn't reach the issue, is what is the significance of having a trustee in Massachusetts? One of the defendant trustees in Massachusetts, is that significant? Does it matter? And it does. And the reason that if I may, Judge, the reason that I raise the issue of Florida in terms of place of trust administration in Florida is that Florida has the same rule. Where is the trustee located? In this case, the trustee is located in Massachusetts. There are no trustees in Florida, there are no beneficiaries
But
in Florida.
even if, sorry to interrupt, even if you had a trustee in California and one in Rhode Island and one in Massachusetts and one in Nevada, if the settler wants it to be administered in Kentucky, and we look first to the instrument, does it say this is where it's administered? Okay, court has jurisdiction. If it doesn't, then it's a judge's responsibility to determine what the intent is. I mean, even Walton versus Harris says that. And so your claim is that the judge erred in determining her intent.
I agree with you, Judge, that the trust language governs. And what the trust language says is that this trust agreement shall be construed, governed, and administered in accordance with Massachusetts law.
The 87 trust,
Correct.
not the changed one.
Correct. And,
So-
and our argument has been, I'm sorry, Your Honor.
No, go ahead.
Our argument has been that that is how Mary kept it for 29, 30 years. and 5 years prior to her death, that she changed the governing law, did not designate a place of trust administration, and it's at that point that the court then has to ask, then what is the place of trust administration? What factors do we look at to determine that place of trust administration? And one of the factors here in Massachusetts is, where is the trustee located? Where is the beneficiary? Where is the plaintiff located? Is Massachusetts the operational base? Did the distributions take place in Massachusetts? Are the records kept in Massachusetts? Where do the primary beneficiaries reside? Where were the alleged wrongful acts, the acts that we allege in the complaint, where were those wrongful acts? Where did those take place?
All right,
Well, those took place in Massachusetts.
I see that your time is up. Do my panel members have any other questions? All right, thank you.
Thank you.
Good morning, Counsel.
Still good morning. Good morning. So please the court, Edward Notice McConerty from Hemingway and Barnes, on behalf of the appellees, Hannah Tucker Clark, Stephen Clark, and the other beneficiaries. Let me just say a couple of things. One is the argument here clarified some questions that I thought were left open by the brief. I find it very important that Ms. Diaz-Alonso has agreed that this is governed by the Massachusetts Trust Code and that we determine subject matter jurisdiction by Massachusetts law.
So tell me why that is. I mean, we are obviously applying Chapter 203E, Section 203. That's the jurisdictional requirement, right?
Yes.
But we have to, as part of that, we have to determine whether the principal place of administration is, right? So we look to the trust, and the trust says, as restated, all matters involving the validity and interpretation of this trust are to be governed by Florida law. So why do we not look at Florida law to determine whether the principal place of administration of the trust is?
So my answer to that would be two things, Your Honor. Counsel has just agreed that it would be governed by, that subject matter jurisdiction is determined by Massachusetts law.
Well, that doesn't matter. There is a right answer here. So the first argument you make in your brief is it's covered by Florida law. You seem to be changing that position. So is it Florida law or Massachusetts law? Do we follow what the trust itself says as restated, or do we do something different?
So two things, Your Honor. One is subject matter jurisdiction would be a matter for the courts of this Commonwealth to determine by Massachusetts statute. And the Massachusetts statute says that specifically the Uniform Trust Code provision you've talked about says that these courts in Massachusetts will not entertain trust disputes like this if the principal place of business is elsewhere.
That's right. So how do we
Florida
determine
courts,
what the principal place of administration, what law do we look to determine that issue?
Since that's a Massachusetts statute, we look to the Massachusetts law on that issue. And
Why wouldn't we follow what the trust itself says?
Because the trust itself doesn't determine subject matter jurisdiction. It's the law of the Commonwealth. And, Your Honor, let me just say, the result is the same either place. Whether you apply Florida law or Massachusetts law, doesn't matter.
It's somewhat, the test is somewhat different, so it's important. It is. And it's, I think actually, your position is a little stronger in Massachusetts law than it is under Florida law. That's why it's really important to figure this out. I just don't understand why we wouldn't follow what the trust says. You interpret me according to Florida law. Why wouldn't we then apply Florida law to determine where the principal place of administration of the trust is?
So I agree with you, Your Honor, that our position is easier to argue under Massachusetts law than it is under Florida law, which is why I think it's very important the other side has conceded the point. But let me address your question. I don't think the trust itself can determine subject matter jurisdiction. Subject matter jurisdiction is a matter for the Commonwealth of Massachusetts to decide on its own, based on its own statutes, as to whether or not it wants to entertain an action. That's
Yes,
different from something...
the jurisdictional statute that we're dealing with refers to this term, principal place of administration, and we have to figure out what that is. It's not, that doesn't mean just because of the Massachusetts jurisdictional statute that Massachusetts law applies to how we interpret the trust. We looked at the trust says, interpret me according to Florida law. So why wouldn't we then apply Florida law as it applies to where the principal place of administration is?
Your Honor, you're focusing on this issue in fact, the Uniform Trust Code says that if the Uniform Trust Code has a provision and it doesn't clarify an issue like this, you look to Massachusetts common law. The Uniform Trust Code did not override or change Massachusetts common law. It's consistent with common law, and if you have a question about interpreting a phrase like this in the Uniform Trust Code, you look to Massachusetts common law. That is not addressed in the briefs because the point you've made was not really argued clearly in the brief by my
I just feel like you're changing your position because your first argument in the brief is we look to Florida law. You say that, we look to Florida law. Now you're changing that position, and it's apparently because the Massachusetts law is more advantageous to your position. But that's not, this fundamental question, I don't think you're answering as to why wouldn't we look to what the trust itself says as to how it should be interpreted?
All right. Your Honor, I do not believe I said anywhere in the brief that this was governed by Florida law.
So on page 19, argument number 1, it says the trust principal place of administration is Florida.
Yes.
Right? And so then so what is your, I guess I'm still not clear. Are you arguing it's Florida? No, you're arguing now it's Massachusetts. We should be...
Correct, Your Honor. And it's very consistent, and it's both. For one thing, for the first 40 years, from 1987 through, 2016 or whatever, 30 years, I guess, there is no dispute of any way as the fact that this was the place of administration was in Florida. And that would be governed by either Florida statute, they're talking about principal place of administration, or Massachusetts. Either way. But I do think it's significant that the other side, the appellant here, is arguing and conceding today that Massachusetts law governs this point. And so I addressed the question of Florida law in large part because I think we needed to look at both. This place of administration was in Florida for those 30 years. And then it was even more strongly true after 2016. And there's another thing I want to bring up here, Your Honor, and that is, Your Honors.
I'm sorry, before we get away from this.
Okay.
Page 18, footnote 9 of your brief. Massachusetts law, of course, controls the jurisdiction of the Superior Court. Correct. However, Florida law controls the construction and interpretation of the trust. And then on page 20, your first argument, under Florida law, the trust's principal place of administration is Florida. So are you moving away from those statements?
I'm sorry, the first reference was to what page, Your Honor?
Page 18, footnote 9.
So Massachusetts law controls the jurisdiction of the Superior Court, period.
Yes. However, Florida law controls the construction and interpretation of the trust, period.
The other side argued below a lot about Florida law, so we addressed that here. But the fact
And your first
is,
argument on where principal place of administration is, under Florida law, the trust's principal place of administration is Florida. And I know you're saying you make a backup argument about Massachusetts law, but I just want, your position today is that you think it's actually Massachusetts law, not Florida law.
yes, Your Honor.
Even though you don't argue that in your brief.
Yeah, it's on page 22.
I think we did argue that right there at the beginning of that footnote, paragraph 9, footnote 9, Your Honor. The fact is, below, it wasn't clear what they were relying upon. We addressed Florida law, we addressed Massachusetts law, and the effect is the same, Your Honor. The effect,
Except
the
that-
standards may be standards may be different, but
They are different.
So for a moment, if if we're stuck on Florida, right, and we find that Florida law applies to the interpretation of the entrust, which also includes the principal place of administration, since it wasn't specifically designated, Florida says the principal place of administration is the trustee's usual place of business where the records pertaining to the trust are kept, or if the trustee has no place of business, the trustee's residence. Your sister says all the records were kept in Massachusetts. So even though she was arguing Massachusetts law, the Florida statute seems to kind of hone in on where are those records. And I didn't see in the judge's decision where the records were kept.
Very important point, Your Honor. The fact is that everyone is in agreement here, and it's very clear under the law, the burden of proving and bringing forward that kind of testimony is on the appellant below. The appellant is, when their affidavit's submitted in support of a 12B1 motion, it becomes a factual matter. And if she wants to prove that the records for Massachusetts are here in Massachusetts, it's her obligation to show that.
Was there any evidence submitted?
There was evidence submitted that all the records were kept in Florida during the time that Mary was alive and in Florida, administering everything in Florida. And that is in the affidavit of my client, Hannah Clark.
Was there any evidence that the records were kept in Massachusetts, other than counsel's assertions today?
No.
And I think that's a really good point. The problem is that you have co-trustees for this, right? There are 3 trustees.
Right.
So the provision of Florida law says in the case of co-trustees, the principal place of administration is, and there's 2 conditions that don't apply, corporate trustee and professional fiduciary. Then we're stuck with C, the usual place of business or residence of any of the co-trustees as agreed on by the co-trustees. Assume for the second that's the standard here. What is your best argument that that means it's Florida?
So, Your Honor, that statute says, right, you're looking at C, section C.
Yes.
It's the usual place of business. So the usual place of business always was Florida. Nothing has changed. We have no evidence that anything was changed after that. Or the residence of any of the co-trustees as agreed upon by the co-trustees.
Mm-hmm.
So they have agreed that's in Florida.
And I'm not saying you're wrong, but what is the basis for that agreement? Where do we find that agreement?
There's a specific reference in the affidavit of my client, Hannah Clark. Give me 1 second, Your Honor, I will pull it up. In paragraph 5 of that affidavit on the record appendix at page 40, the trust has its principal place of business in Florida.
Yeah, so that's the
Paragraph.
affidavit of Hannah.
Yes.
Right? And she's one of the trustees.
Correct.
I think you said in your brief, it's apparent from the motion dismissed that Hannah and Stephen agree that the trust's principal place of administration is in Florida, right? So
Yes.
by joining on to this defense of the lawsuit, that's where we find the agreement that everybody agreed it was.
It's actually more explicit than that, Your Honor. If you look at that same affidavit of Hannah Clark at paragraph 11, record appendix 41. In our capacities, we have never moved the trust administration from Florida to Massachusetts.
Again, that's from Hannah, right?
Yes, that's from
And then
Hannah.
where do we get, we just sort of,
We have, so.
Stephen is sort of implicit, or the fact that Stephen joined on to the defense.
Yes, Your Honor.
Okay.
And you know, we have this from Hannah Tucker Clark, and then we have nothing to the contrary from the other side, and the burden is clear. It's their burden. If they want to dispute that, they have to come forward and say something, and they didn't.
Okay.
And even under Florida law, what you have is a situation where if there is a principal place of business, has that changed? Did it change with Mary's death? There's no indication that it was changed after Mary's death. In fact, as you mentioned, Your Honor, it was just a matter of the trust winding down and the trust being distributed, and it more or less terminated with Mary's death, and it's just being distributed. So no change was made. And under Florida law, and under that specific provision that is included in the record appendix, if the trustees have an obligation to continue to administer the trust in an appropriate place. That appropriate place was Florida, always was, continues to be. And there's a requirement in the statute that if the trustees want to change the place of administration, they have to give notice to the beneficiaries. Not done.
Can you address Ms. Diaz-Alonso's argument that we look to the 87 trust and its choice of law provision being Massachusetts, and we can infer from that that also meant that the place of administration was Massachusetts?
I'd be happy to, Your Honor. I don't think that argument carries a lot of weight. The trust specifically did not say anything about where the place of administration was, even in 87. It said what the governing law would be, right? And then all the other factors that you look at overwhelmingly establish that it was administered in Florida. You look at the Walton case sets those out exactly, and it talks about the place of residence of the trustee. That was Mary, overwhelmingly. She was, in effect, the only trustee while she was alive, right? The assets were in Florida. The trust was executed in Florida. All the business of the trust was done in Florida. So that overwhelmingly, during Mary's life, that was true. And even though you may say Massachusetts law, the place of administration was in Florida. And then it was eliminated in 2016. Now, you know, that rule of statutory construction, that if the law has changed, you look at what the intent was, the elimination of the reference to Massachusetts has significance. It meant she was confirming what the situation was, that it wasn't Massachusetts. I see my time is up. Unless there are other questions, I thank you for your time, and thank you very much.
All right, the matter is submitted. Thank you. We'll call our next case, which is 25P 100, SON TREME versus Michael SHEA and others.
SON TREME.
TREME.
The area in New Orleans, actually. There's a TREME section of New Orleans. He actually changed his name to be a son of TREME. That wasn't his birth name. This is
Interesting.
an interesting little tidbit that has nothing to do with this case. But
All right, well, Attorney Abraham, do I have that right?
yes, you do that. Yeah, right.
Okay, well, please begin and welcome.
Thank you, Your Honors. May it please the Court, my name is Andrew Abraham, and I represent SON TREME and Belle TREME through her mother and next friend, Heather. The fundamental and the biggest issue in this case, Your Honor, I suggest to you, is whether an MRI examination or an MRI report is an examination for the purposes of 23379G. The trial judge in this case had made a determination that a MRI examination is more akin to a record review. I suggest to you the import of this is actually extremely important, not just for this case, but for how personal injury cases and other cases would be practiced in the Commonwealth of Massachusetts. Because if they were to take the judge's interpretation that an MRI report or a CT scan or an X-ray report or an ultrasound report or even a pathology report was a record review, then the whole point of 23379G was not to require doctors, physicians to be able to come into court and to testify as to the opinions that are reached in them. And I suggest to you, Your Honor, that if this were to be true, if this were to be upheld, that would change. In order to get an MRI report in, because MRI reports by definition are opinions, they're diagnoses, and therefore opinions, they're subjective. A radiological interpretation of a scan saying there's a herniated disc or if there's cancer or whatever the radiology, there's brain damage, whatever it is, you would have to call in that physician. You wouldn't be able to rely on the records. And I think that's against the fundamental purpose of 23379G. And I suggest to you, Your Honor, when you look at the judge's decision, it's in the record appeal, page 230, he says a review of the records leads to the court of a finding that the opinions of Dr. Snyder are more akin to a record review than that of a physician who treated or rendered care to a patient. And I think the very substance of that decision shows a fundamental misunderstanding of 23379G, because when you look at it, it doesn't require the physician to treated or rendered care to the patient. What it says, what the plain language of 23379G says, it talks about someone who's rendered or treated to a person, or any report of any examination of an injured person. And that was left out of the decision, Your Honor. And
What about the secondary basis for the judge's decision, which is that you didn't provide it in the appropriate form for it to be admitted at trial?
You know, Judge, I would argue, number one, that was never raised by either Walmart or CVS at the trial. They filed a motion in limine.
But does it have to be raised, though? If the judge says, look, just because nobody here's made this argument, but I have noted that this is inadmissible, and here's why, the judge is not...
I would rely, Your Honor, on the Merce case that I cited, and where this was, in the Merce case, the physician didn't sign the attestation, no one signed the attestation at all. And the court, basically, what the court said was the 233, although technically not complied with, there was plenty of opportunity given to Walmart or CVS of the notice to intent to offer this opinion into evidence, this report into evidence, and they had plenty of opportunity to be able to go into, and if they wanted to call the doctor to cross-examine, which is what 23379G allows. So I think there was a waiver, and I think if you look at it from technical noncompliance, what the Merce case says is that even if there's technical noncompliance, as long as the spirit of the rule, the spirit of the rule was complied with, then that was fine. I mean, I would point out, Your Honor, that had this been raised on October 16th, I believe, when the pretrial briefs were filed, we could have gotten, no one raised this as an issue.
You could have,
Yeah,
right?
And this wasn't even brought up, this was not brought up until the judge's decision on November 28th, and by then it's too late.
Well, but no one had an obligation. I mean, one could argue strategically, right? If you were the other side, why would you point that out? Why not wait until till it's too late, right?
Yeah,
I mean, isn't that a good lawyering, frankly?
Well, maybe, maybe not. I guess I would rely heavily on the Merce case that says technical, as long as the spirit of the statute has been complied with. If you look at the Merce case, the spirit of the statute has been complied with, and the defendant has been given enough opportunity to know this is going to be entered into evidence.
But remind me, weren't the facts different in that case? Wasn't that the case in which initially it didn't comply because it didn't have the attestation that was required, and then later, like on the eve of trial, they got it right, and the judge had said no, and it was reversed because eventually they got it right.
The other thing
is that the case?
I actually reread the decision this morning while I was waiting in here. I never remember seeing that in the decision itself. The judge did hold, the trial judge did hold that it doesn't require the signature at the time of the serving on the 23379G.
Right, but they later cured it.
I wasn't sure if it was, I didn't see in the decision it was cured. The point I also would make is that the judge brought this up without giving us sua sponte. It's not clear whether or not the Simon Med, Simon Med is a organization, like we get Shield, it's akin to a Shields MRI here. It is and whether or not it's, because a signature of the physician is not required if it's an applicable organization, and because this was brought up so late, we weren't able to try to correct that defect. So that's what I would rely on that.
But so, tell me where I'm wrong in this thinking. The legislature under 23379G created the statutory ability so that all of the doctors wouldn't be in all of the courts. They'd be actually treating people, right? And so they crafted it in a way that said, if you put hands on and you have treated somebody, those, as long as it has the proper authentication, are going to be admissible. And one other thing, right, which is if you've done an examination. So because of the reliability that doctors are treating people and not in preparing witnesses to testify about causation, et cetera, that we are going to allow their reports to come in as admissible evidence. And here, the Simon Med was an expert's reviewing this and says, let's get an MRI. And besides which, we can get to it in a moment, the expert testified a lot about the radiology report, right? But my point being is that this is, while this case is being litigated, unlike going, because I've got a bloody gash on my head, and I'm going to the emergency room and we're trusting the reliability of those treating physicians or examinations. So why is it wrong to say this type of search for what's going on by an expert in anticipation of litigation doesn't fit within the parameters of 79G?
Your Honor, under O'Malley versus Sosky, and also I think it's Commonwealth versus Schutte, if I remember right, expert reports are admissible under 23379G. The fact that there isn't a treating physician.
No, the expert, yes, but the underlying, so they're relying upon a Dr. Schneider. So it wasn't the fact that your expert couldn't testify and testify what he or she relied upon. It was the underlying report.
Yeah, but underlying reports, I understand that, but underlying reports in the O'Malley versus Sosky, and I believe it's Commonwealth versus Schutte case, the underlying reports are admissible under 23379G, even if they are retained for the purposes of litigation. In fact, the judge in his decision actually noted that he's not excluding it because it's an expert. So the fact that they're experts under...
If they were examined, right?
Yeah, and so again, it goes back to the fundamental question, is the MRI an examination? And it doesn't make a difference who did it, who ordered it. Is the MRI an examination or is it a record review? My point is that when you take an MRI examination in any hospital, whether it's an expert or not, you go into the machine takes pictures of your brain, the radiologist looks at it and makes an interpretation on it, whether it's a treating or an expert. And so the fact that this one was for expert purposes does not make a difference under the statute. That's why it says here, or any examination of a physician. The statute says any examination of said injured person.
Right, but the statute says it has to be subscribed and sworn to by the physician, right? I mean, you have on page 71 of the record appendix a medical record certification, which I assume is like custodian of records, and I think. As I understand Justice Walsh's point, it's like this statute makes the legislature made this deal. We're not going to drag all these doctors into the court, but they have to sort of provide this kind of level formality to allow these records to go into evidence, and you didn't just quite do it here.
Yeah, but again, going back because of the late notice, this was
it's an arguably technical difference, but it is in the statute. That's the problem, right?
Well, but except that Simon Med, for example, MGH, in this case, in and of itself, in this case, a ton of MRI reports came in through hospitals. None of the 233 certifications were signed by physicians. Hospitals and organizations like that, it's not the physician that has to sign it, it's the keeper of record of the facility. In that sense, we did comply with that, Your Honor. And so it's not, it doesn't require, for example, if I get an MGH record that has an MRI report in it, the physician does not have to sign it. So the statute actually sets out a whole framework where the physician doesn't. I don't think they also don't want physicians have to sign everything all the time. It's a little bit different. This was a doctor's report done outside of the hospital or outside of the, as part of a pure, forensic examination. Then I think the doctor has to sign the 233 examination.
Sorry, go ahead.
Well, I was just going to say, so what material difference would it have made if the report had come in? Because at trial, Dr. Oshanek testified quite extensively, frankly, right, to basically the substance that was in those reports.
Did, Your Honor, I will tell you, and this is the harmful error the harmful error, and that's a plausible showing that would have made a difference. First, I want to point out that this was a extremely close case. The jury was out for 4 days, and Dr. Oshanek testified on November 16th. That was the date that all of those images and the substance of the report was shown to the jury. In between November 16th and the time they deliberated, December 7th, and then they asked for, they specifically, I think one of your earlier says, how do we know what a jury's thinking? One of the early ones, we know in this case they were looking for expert reports. They specifically asked a question, where are all the expert reports? So they would have been looking for this. And in between November 16th and the time of the deliberations, and specifically the time of December 7th, that report was not allowed to be used on cross-examination of any of the experts. And I brought here specifically the testimony of Dr. Dalton. This was a case, Your Honor, that was whether or not the only real issue in this case really wasn't liability, was whether or not SON TREME suffered brain injury. And under the Gompers case and under the Grant versus Lewis and Boyle, when the excluded evidence relates to a central issue in the case, it's almost always harmful and prejudicial if it was excluded. And in this particular case, all of the defense called 4 or 5 experts. Their brief kind of makes the point. They called all of these experts to say he didn't have any brain damage. In fact, CVS contested whether the fall that happened on November 20th, he even struck his head because he didn't have any bruising on his head. Well, this report showed objective evidence of brain damage on the left side of his head, which is where his head struck. And the
But
fact
didn't
that
Oceanic testify essentially to what you...
he did,
to
but-
everything that was actually in the reports, and it's just the reports themselves did not come in, nor did the images, and the judge found in his findings, right, that he doubted whether, the jury of laypersons would be able to, the reports would actually be able to assist them right?
I appreciate the judge made that finding. I'll tell you, this is why I think it's wrong. Number one, this was a very long trial, right? The very fact that the jury's asking for reports, I mean, this was a very, very long trial.
And it could be, we have no idea why the jury's asking the questions they asked, but and it could be that they couldn't, it was a very long trial, there was testimony from numerous experts they wanted to be reminded of, they couldn't remember exactly what Dr. Oceanic had said, right? We just don't know.
Right, but again, the standards, we'll never know this because we never get to interview jurors. It's a plausible showing that it wouldn't have made a difference. Here we have some insight that the jury was looking for expert reports. But more important, like Dr. Dalton, one of the defense experts, got up and testified that all of the radiological reports showed that his brain was normal. And I wasn't able, because this report was not in evidence, I could not cross him on it. I could not use it in my closing. Dr. Niyogi was another expert retained by Walmart to say that all of the imaging was normal. Dr. Ducati, they called a number of experts where my failure to be able, because the report was not in evidence.
But you had called, but Oceanic had testified.
No, I understand that,
right?
but it limited, the prejudice to me was that it limited my cross of the defense experts on the central issue in the case of whether or not there was brain damage. It limited my cross because I can't use the report. In fact, one time in front of Dr. Niyogi, I tried to cross him about a portion of the report and the judge wouldn't let me because he said it wasn't in evidence. So that's the prejudice. And then, of course, I couldn't use it in my closing to remind the jury. And then on a very long trial, I think, Your Honor, I suggest to you that under the law, I got 6 seconds left, that it would be very hard to say that it could have made an effect, the fact that we have objective evidence of brain injury where the sole issue in the case is whether or not he suffered a brain injury. Thank you, Your Honor.
Thank you. Attorney Lantry.
Thank you, Your Honors. May it please the court. My name is Jacob Lantry on behalf of Walmart Transportation, LLC. There are only 2 questions this court needs to answer to be able to affirm the judgment of the trial court. First, whether the trial judge abused his discretion in precluding the admission of the Simon Med report as an exhibit at trial. And 2, if he did, whether admission of that report would have made a material difference in the jury's verdict. I don't think this court even needs to reach the second question because the answer to the first question is no. But even if you determine that the trial court abused its discretion in precluding admission of the Simon Med report, on the record before the court, the answer to the second question is also no. As you know, the abuse of discretion standard is a high bar and one that requires a determination that the trial court made a clear error of judgment and a decision that falls outside the range of reasonable alternatives.
I'm just going to interrupt you only just because I want to kind of get to the heart of the questions that you raised. Opposing counsel says that radiologists' reports, because they're not technically radiologists, don't technically examine patients. So therefore, what do you say to their argument that?
I think the legislature was very clear in its writing of 79G that to admit a report under that statute, as the plaintiffs tried to do in this case, it requires, in the first instance, treatment or examination of the person. And necessarily, by nature of the work of a radiologist or a pathologist or any of these other non-clinical specialties, there is not an examination of the patient.
But the radiologists, I mean, what do radiologists do? They look at medical images of patients, right? So the patient doesn't have to be in the room with the radiologist, but the radiologist is looking at a medical image of the patient's body. And I just, it seems implausible that the legislature meant to sort of take this entire important area of medical practice out of the realm of 79G.
Because a blood test would be the same, wouldn't it?
Yeah.
I mean, they get a vial and they see that there's something in there. A doctor says there's something in the blood, right?
And I think what's clear from the cases I will start with is that this suggestion that radiology reports or pathology reports are now not going to be or cannot be admitted into evidence is just, it's not accurate. Those cases, those types of reports can and consistently are admitted under the medical records statute 79. And so, and many of the cases that are cited by the plaintiffs in their brief involved admission of these types of records under 79. 79G, in order to admit reports of the type that the Simon Med report are, based on the 1988 amendment to the statute that the legislature made, requires first the treatment or examination, and then, even if, setting aside that issue, as a number of you hit on, we then have the attestation requirement that simply was not met here. And that seems to have been conceded.
Okay, before you get to that, and I think it's a better argument for you, but just the CVS motion in limine said that the imaging was not performed for the purpose of diagnosis or treatment, right? And that's not correct, right? I mean, radiologists can diagnose conditions by looking at medical images, right? So if that's the standard, then that seems clearly wrong. I don't think you're right on the examination piece either, but it just, radiologists diagnose conditions by looking at medical images. Wouldn't you agree with that?
I think that is probably true. I will concede that, Your Honor. But what I would say is that what Section 79G says is that it must be based on treatment or examination. And I would say the issue before this court is, at best, just whether this was an examination. The plaintiffs have conceded in their brief that this was not treatment. What Dr. Snyder did with
Sure, but it was an
not
examination,
treatment.
right?
And so the issue is whether it was an examination. And there is no evidence in the record before this court that Dr. Snyder was ever in the same room as Mr. Treme, met him or examined him, as the plain language of that word could be taken to mean under the statute.
Okay, I interrupted your pivot to the subscribed and sworn issue.
Well,
so.
and I just wanted to make sure I touched
Before
on.
you pivot, though,
Stay in
before you
position.
pivot, under Plain 79, a radiology report, admissible?
Under 79,
Right.
I would assuming it's all the other requirements of that statute are met, and it's a medical record as contemplated by 79, a radiology report would be admissible under that.
So it doesn't need examination, doesn't need the license, the treatment and diagnosis, doesn't need the hands-on language, right?
I believe that to be true, yes. That was not the basis under which this report was sought to be admitted in this case, and so I don't think that matters for purposes of the decision this court needs to make.
So do you think a radiologist report would be admissible under 23379G?
I think if there is evidence that it was for treatment, then, and the attestation is included, then yes, absolutely. And if there was also an examination, then yes, absolutely. Barring that, I think the legislature would need to amend the statute to make it clear that someone doing the work of a radiologist is meant to be included under 79G. Otherwise, I would say that the language of it seems to exclude those types of specialists. And so to your point, there is a way in which this type of report could have been admitted under 79G, and as if it had been based on treatment of the patient, and if it had come subscribed and sworn to under the pains and penalties of perjury by the physician. And as we saw in the plaintiff's brief, and I think conceded again here today, that was simply not met, that requirement. And that's what the trial court found. And what this court is looking at is whether the trial court abused its discretion in precluding the report on those grounds. And based on the record, I don't think this court can say it was an abuse of discretion to preclude admission of a report that necessarily didn't meet the prerequisites required under the statute.
On the attestation issue, set aside the examination point, do you agree that a lot of records came in that weren't properly attested to?
That seems to be the case, and if those records were at issue, we would have waived that argument.
Okay.
We didn't as to this one.
This wasn't something that you or CVS, you didn't challenge the attestation issue, or did you challenge it at trial?
We did, and
Okay.
I would point the court specifically to, I believe, page 95 of the record appendix, in which trial counsel for Walmart specifically confirmed that we were not waiving challenge to the technical requirements of 79G.
Is there a problem that some records come in and this objection isn't raised, and other records, this important record is kept out on that basis? Is that an issue? Like just in overall fairness?
I don't think it is, because, and as Justice Tan highlighted, it could very well have been a trial strategy issue. There was reasons that maybe those other records that Walmart and or CVS didn't have a problem with them.
Maybe they helped them, right? Those records helped them and they didn't.
But can I go back? Can you go to Record Appendix 95, which is amazing that you can cite to that. What does footnote 1 say? The parties have agreed to waive the technical requirements of 23379G for the purposes of authentication, but not admissibility. And the portion of 79G that is reserved seems not to have to do with attestation or authentication, which is a signature to me. It has to do with whether or not it was prognosis and treatment.
So forgive me, Your Honor, it should be page 90.
No, I'm
95.
No,
95.
You had it right. You had it right.
It's the motion in limine.
And I believe, actually, no, you know what? I misspoke. It should be the supplemental record appendix.
But can you answer, Justice? I'm just interested in, she pointed out that on Record Appendix 95, the motion in limine of CVS, the footnote states that parties have agreed to waive the technical requirements of authentication under 79G.
Well, the first thing I would state is that was made by CVS and not by Walmart. And on the record, and again, I apologize, it's in the supplemental record appendix. It should be at page 98. That those technical requirements were not agreed to be waived by Walmart.
This is the supplemental 98.
I mean, CVS is the only party that moved to exclude this record, right? Not Walmart.
Because I don't see anything from Walmart that argues it.
I believe that's correct at the trial court level. I don't, as Justice Tan pointed out, I don't think it matters for our purposes today.
No, it somewhat does, though, doesn't it? Because if Walmart didn't object, CVS objected, but said, hey, not on authenticity, but on the admission as to whether or not Simon Med is a examination or treatment diagnosis. We're preserving that. That's the only thing that was left preserved. And so Walmart says nothing, CVS says just this little bit, but as far as attestation, authentication, we're good with that. Walmart doesn't, so how do we even get to it if it wasn't properly, I guess it.
So I think, again, I would point to Supplemental Record Appendix 98, and this is where I think this discussion, there's a discussion on the record.
Right, I see what you're saying.
Yeah, and Attorney O'Hara at the bottom of page 98 says, Walmart did not agree to the waiver of the technical defenses as to the admission of the report. And if I could, just with the remaining time, because I think fundamentally an important issue here is even if it was improper for this to not have been admitted as an exhibit, as Justice Tan pointed out, Dr. Oshanick testified in great detail to the substance of this report. Everything that the plaintiffs claim the jury was deprived of was actually presented to the jury by Dr. Oshanick. He talked about the findings of the report, showed the jury images from the report, and so the argument that the jury was deprived of this is simply not supported by the record. And given that, this court can say with substantial confidence that admission of this report would not have made a material difference in the jury's finding.
I guess the argument, as I understand it from Mr. Treme, is that the defendants brought in all these reports, jury had them in their hands, and we had this countervailing report, and it was kind of kept from the jury. So, when the jury did ask, can we see the reports, during deliberations, right? So, is there just some? I take your point that the content came in through the doctor's testimony, but is there something prejudicial about one side having paper reports available and the other side not?
So I don't think, and the record before this court, if I can finish answering this question, the record before this court does not indicate that other expert reports were with the jury. I don't believe they were. So this general question about can we see the expert reports, again, as I believe it was Justice Tan pointed out, we don't know who they were referring to when they were asking for the expert reports. And I will also note that the Simon Med report was not admitted into evidence, so they necessarily weren't asking for this particular report. They didn't know it existed as an exhibit for them to be given. So I think that's a red herring that doesn't indicate anything as to what the jury might have been thinking or somehow indicates prejudice. So for all those reasons, I think this court should affirm the judgment of the trial court.
All right, thank you. It was very well argued on both sides, and the matter stands submitted. All right, the final case that we'll hear today is docket 25P474, Mark Miller and others versus Harold Miller Jr. and others. All right.
Thank you.
Good afternoon, Attorney Dunbar.
Good afternoon. May it please the court, my name is Attorney Ronald Dunbar. I represent the appellants Harold Miller Jr. In this case, the trial court erred when it found that Harold Miller Jr. converted the $290,461.23 from the accounts at Edward Jones and at Webster Bank. And the evidence at trial was that Mr. Miller had the authority under a durable power of attorney and also the power as trustee under the Miller Family Trust and the Miller Family 2013 Irrevocable Trust. And although there are a lot of trusts mentioned in the record, those two trusts are most important here because they were the owners of the accounts at Edward Jones where the money came from.
So your two issues on appeal are first the admission of the lay testimony regarding kind of, mom's mental ability. And then second, the attorney's fees, correct?
Correct.
So can we start first on the lay testimony? And I've reviewed, but please help me understand, I've reviewed the testimony and I don't see, counsel, where there was any objection to the admission, first of all, to this testimony.
Yeah, so I didn't try the underlying case, and I noticed that as well from the trial transcript. I also noticed on the docket some motions in limine directed at this that don't appear to ever have been ruled on.
So in your brief, you state time and time again, counsel objected, et cetera, et cetera. I've done the best that I can, but I'd like for you to specifically point to me on the record, in the record, where it is that trial counsel objected to the admission of this type of testimony.
I think the only objection that I could find, Your Honor, was the filing of the motions in limine. And with respect to the argument now, I'm more focused now on sort of the last argument made in the brief with respect to the authority of Mr. Miller to take the money that he took, that it wasn't actually a conversion, and that the admission of the lay testimony as to the mental capacity of Marjorie, although I think colored the trial court's understanding of what was going on and the decision, isn't really germane to sort of the result in the case. I think the real issue is whether under the durable power of attorney and as trustee under the trust documents, he was entitled to use the money that was taken.
Okay, but what we have before us, respectfully, is limited to the two issues that you briefed on appeal. One, lay opinion, and two, attorney's fees. I don't see it all briefed. I see you argue that my client, properly withdrew this money, but I don't see that legally it's preserved.
It's the argument, Your Honor, and it's probably colored by the admission of lay testimony argument that was included with it. It's the argument that my client was entitled to withdraw the money pursuant to the durable power of attorney from the Webster bank accounts and was entitled to withdraw the money from the Edward Jones accounts pursuant to being a trustee of those two trusts.
Okay, so just so
and I admit it's not as articulate as I would like it to be.
That happens to me all the time, but
Yeah.
let me just make sure I'm clear because I want to make sure that I'm being fair to both sides. Are you waiving the argument about lay opinion?
Yes, I don't think that that's important at this point, Your Honor. I think that the real issue is, did Harold Miller Jr. have the authority under the durable power of attorney and as trustee of the two trusts to withdraw the money and use it as it was used?
Thank you.
And with respect to
essentially on that really just goes to the merits. You're just saying the judge got it wrong. The judge assessed the facts incorrectly, reached the wrong conclusions about Harold Miller Jr.'s authority. You're just going to the merits of the case.
Right. It's if you look at the trust document, in particular the 2013 irrevocable, the Miller Family 2013 Irrevocable Trust, it allows Mr. Miller to take money for reasonable compensation. It also gives him the authority to disperse money to the siblings, including himself. And the testimony from Mr. Miller at trial was that he dispersed the money as compensation to himself and in other instances as gifts. And the trustee is entitled to compensation, and it wasn't really addressed in the lower court other than to say there was no evidence submitted as to what other trustees have charged for compensation. But the case law talks about, you know, they get compensation as it's cited by the judge in the trial court's decision. You look at the trust size, the time spent, the responsibilities. So he testified.
Yeah, but the judge found that your client violated his fiduciary duty to his siblings by withdrawing funds from the investment account, retaining them, using them for his own purposes, including the advancement of his popcorn business, right? I mean, that's the finding, is that he wasn't just taking money to sort of, you know, function as the fiduciary. He took money for his own business, invested in his business. You know, that's the basic issue here, right? And so I'm not sure I understand. You're just sort of saying the judge was wrong to find a violation of fiduciary duty, was wrong to find conversion, but we're just supposed to sort of analyze the facts differently from what the judge did and reached in the findings?
Sure. With respect to the fiduciary duty, I think one thing in particular is the judge read into although the trial court judge did acknowledge that the durable power of attorney did not put any restrictions on Mr. Miller's ability to gift money and gift money to himself, and the trial court acknowledged that he didn't have to take into consideration past practice or the estate plan, the judge seemed to say, well, I'm going to impose that duty upon him, that he should have take those things into consideration when the clear words of the document do not require that. So she imposed a duty on him that actually did not exist with respect to the durable power of attorney. There were no restrictions on the durable power of attorney.
Being a power attorney, you have fiduciary duties towards the person you're representing, right? And that means respecting the wishes of that person, and you can't just take the money for your own benefit.
I agree, Your Honor, but the reasoning that the trial court gave was that it was because Mr. Miller didn't take into consideration the estate plan, which apparently the theme of all the estate planning documents was that all the children would share equally. But when the document specifically says he doesn't have to do that, I think that was an error for the court to impose that obligation upon him when the durable power of attorney did not. I agree that you can definitely violate your fiduciary duties by overstepping your authority in a durable power of attorney, but if you're actually complying with it, I think that would be an error.
So your argument is that the judge's findings of fact are clearly erroneous. Is that your argument?
Well, my argument is that in the rulings of law where the court specifically said that this durable power of attorney required him to take into consideration the intent of the estate plan, that was an error of law, not merely just an incorrect finding of fact. And it's in the trial court's rulings of law with respect to the durable power of attorney.
Again, and I keep harping on this, but where in your appellate brief is that argument? I have argument 1, which is lay testimony, A, B, C, D, speculative, and then as a result, the court erroneously found. So I don't see any argument as a matter of law. I see A, admissions of lay testimony, which is waived, and then secondly, the 1D of your argument, starting on page 17, the court erroneously found the defendant converted funds because they relied upon this lay testimony. But I don't see where the judge, as a matter of law, improperly construed the trust and the ability as the power of attorney to use the money, the judge says, as his own personal checking account. But where is that in your brief, please?
I didn't hear your last.
Where is it in your brief that I'm...
Again, as I said at the beginning, the brief with respect to this issue really sort of almost buries the argument in the third part of the brief where it talks about the trial court erred in finding a conversion with respect to this money because he had the right to use it, and the right was the trust and the durable power of attorney. With respect to the admission of layperson testimony with respect to her mental state, that really, although it did color the decision, on second thought and going over this again and rereading the brief and looking at the trial exhibits, I think the better argument is the one that's sort of buried at the end of the brief with respect to his power and authority to do what he did based on those two documents.
And if we could turn just for a moment, you're arguing that the judge also impermissibly granted opposing counsel's attorney's fees. And can you tell me how you did not apply for single justice?
Yeah, so the case that we're relying on in this brief is the case of Bailey versus Schreiberg, which allows the court to exercise its equitable jurisdiction to transfer this to the single justice. This should have been brought to the single justice. In that Schreiberg case, it was the same situation where the appeal included the award of attorney's fees under 231-6F, and the court made the analysis. We probably don't have jurisdiction over that under 231-6F, so they transferred it to the single justice. So that's all I'm asking with respect to that.
But you didn't, and so you concede that you didn't file within the 10 days?
Yeah, there's a
single justice.
Yes, there's a second mechanism under 231-6F for the appeal, but this Schreiberg case, 31 Mass App Court 277, allows for the transfer to a single justice if a notice of appeal was filed to the full panel. And that's in the footnote to the brief.
Anything else?
If no further questions, I'll rest.
Thank you.
Thank you.
Good afternoon,
Attorney Lang,
Justices.
correct?
May it please the court, my name is Scott Lang. With me is Attorney Kate Kramer. We represented the part of the Miller family that brought this case. We didn't represent the Miller family in the beginning, but we did all the discovery, and then we tried the case. There was a counsel prior to us. I don't think it has any bearing on the arguments that we'll make today, but I wanted to tell you that it did start with another law office. What I would simply say is that we stand on our brief. We briefed what was appealed. We think that we briefed it appropriately. Hopefully you will agree. As far as the trial went, it took 2 days, full days, full testimony from everyone. It took about a month to get a decision, more about 6 weeks to get a decision, I believe. And then there was a further hearing before Judge Sullivan regarding attorneys' fees and costs. Now, I want to say one thing, and I don't want anyone to be offended, but Mr. Harold Miller Jr. was recalcitrant, and it showed on the stand, it showed in his attitude, it showed in everything that we did in the case. And the judge admitted the evidence. She was the fact finder. She ruled against us in some evidentiary matters. She ruled for us in others. The lay testimony, which I believe that now is being conceded, but I will say was observations, not medical in nature, but observations about Mrs. Miller, and that the judge wrote her decision based on the medicals that had been put in under, and I don't even want to say this now, but 233-75G. Now I'm nervous. Now I am definitely nervous, but
Opposing counsel conceded that the issue, right?
yeah, and they were authenticated, and they went in. It showed that she had a real problem with day-to-day type of processing thoughts going back to 2007 right up through her death in 2018, but the fact of the matter was that by 2013, 2014, she was extremely infirmed and did not have capacity and was diagnosed as having dementia slash Alzheimer's pathway. Harold Jr., who had her health care proxy 4 years before she died, took her out of the hospital, put her on hospice, took care of her. There's no doubt, there was no question that he was given credit for any money that he laid out for his mom. He was given credit for any money that he gave to his brother Emerson, who has now passed away, to help take care of his mom. And his mother lived with care. And we give him credit for that. The problem was that he had 65 separate withdrawals from 2 different bank accounts with Edward Jones, which he set up, by the way, and changed as soon as his dad died within a 3-month period, changed all the bank accounts, changed the PO so that no one got any evidence any longer. And when I say recalcitrant, that's what I'm talking about. And he was bold about it and brazen about it. And he said he did it because his mom gave her permission to do so, which was clearly impossible. The poor mother was not able to give permission. He used the money to set up a popcorn company in Popnito, which has 4 or 5 locations. And his mom didn't have capacity to enter into any kind of contractual relationship with him. He basically converted $290,000, of which he had a sixth of. And the reason for that was from the day that they began estate planning, in their trust documents, they indicated that whatever was left after legitimately taking care of either of the 2 parents would flow through the final trust to the 6 children. And Emerson, however, getting, I think it was the house, which is 29, what's the street? Florence Street in New Bedford. So he got the house for his 1/6. Everyone else was supposed to get a 1/6. He was questioned on the stand about compensation. Compensation was his last Hail Mary. And he indicated at the time, well, I took this money because I took all these withdrawals because I was compensating myself. That was not the deal at all within the trust or the understanding or the power of attorney that he would use it as if it was his own checking account. And there were no receipts whatsoever for anything. And in other words, anything that was given credit to him for at the trial was given credit to him for based on testimony, holding everyone's thumb up and saying that was reasonable. You paid health care workers, you had a kitchen redone, you had different things. We will give you credit for all that. Where's the $290,000? And one by one, and by the way, we didn't know the exact number when we first brought the case. We had to apply like a dentist prying a tooth in order to get the records. We finally got the records, we put it together, and this is what we found. And we presented it to the judge, and this is what the judge found. He was never a single trustee ever. He was supposed to be a co-trustee in all the documents with his brother, Mark. And he shut his brother, Mark, out, and that's what the judge found. He not only shut him out by eschewing any kind of relationship, but also at the same time by cutting off the mail flow to him and telling Edward Jones, you can't speak to anyone but me. So he never was a trustee at any time. He tried to use the power of attorney as if he was working out a deal with his mom where he'd draw whatever he could out of the account. The judge found he couldn't do it. We think then that we went for attorney's fees and costs and under the statute. And we had a hearing on that. And the hearing came back that we were awarded attorney's fees, which clearly goes to the benefit of our clients. The clients were charged. They have made payments, but it goes to the benefit of the clients and the expenses. And that was it. When we got the appeal, we felt that the appeal should be taken seriously. We briefed it. If you were to say right now, first of all, I don't think Bailey applies because I think Bailey was a one-off. I think that if you're looking to challenge before single justice, by and large, it's a 10-day rule. We also take and we'll blow one tomorrow, but we take the appeals court's rules very, very seriously. And if we know that we have a deadline, we make it. They missed the deadline. They're now asking you to buck it back. That's up to you. But quite frankly, that Bailey doesn't say that any time the appeals court decides they'll send it back to a single justice, the way I read it, I think it's basically said in this case we will. In the future, it's not an automatic free pass. That's basically, we stand by our brief. That's basically my argument. I'm happy to answer any questions.
No, the panel has no questions, so we'll consider the matter submitted, unless there's anything else that you want to say.
No, thanks very much. Happy New Year. Thank you.
Thank you. The matter stands submitted. We'll close this hearing date. I want to thank the court officers, our excellent timekeeper, and